matter. It's not in the list. I'm mentioning the there was a company execution application which was opposed by filing an application for dismissal of the same. On the ground that the matter was pending before the BIFR, and because of that it should not be continued. Some development has taken place. Now they have agreed to pay the 30 lakhs of rupees is recorded in the order also. Now, that matter may appear any day, subject to your lordship's convenience, but it can be sorted out in 1 day.
All right.
Lordship, kind leave Lordship the execution application. Last day I mentioned it, Lordship was pleased to ask me to take a assignment. The 2 execution applications. Now it has been assigned to a regular bench. It is stated. Deeply.
My lord, may I have my lord kindly to mention one section 34 matter, my lord. What happened? I am for the petitioner award data. 34 application was allowed, but 37 court held that since the matter was decided in non-commercial determination, so it will be heard by the commercial division. My lord, be kind enough to come to only paragraph 41 and 42.
But what do you want?
41 and 42. This
Sir,
is the
what do you
order.
want?
My lord, inclusion in the list, section 34. It will be heard in the commercial division.
Inclusion in the list?
My lord, the division bench held the matter was to be heard by the commercial division.
Right.
It was heard in non-commercial division. So,
Then you have to file.
Liberty has granted to my client to mention before your regular commercial bench. My lord.
Show me the order.
My lord, this is the order for, say, paragraph 41 and 42. That is the finding of the division bench.
কনভার্সন চান নন কমার্শিয়াল থেকে কমার্শিয়ালে কনভার্সন করে ওখানে হিয়ারিংটা করতে হবে
মানে জিজ্ঞেসই কোর্ট পেরিয়ে পঁচাডোবাতে
এটা তো এমনিই করে দেয়
Should,
কনভার্সনিং শুধু একটা কেন তাহলে সবই করা উচিত যত নন কমার্শিয়াল আছে সব কমার্শিয়ালে টার্নভার তা নাহলে এরকম এমনিতেও কয় প্রবলেম অ্যারাইজ করবে আর হিসাব অনুযায়ী দেখতে গেলে সত্যিই নন কমার্শিয়ালে কোনো ম্যাটারই হয় না
My lord, commercial number has been given by the registrar 922 of 2025. My lord, this is I'm mentioning upon notice. My lord, by the dint of this order, I applied to the registrar. Registrar directed. This is the current number of the commercial.
তাহলে শুধু শুধু ইনক্লুশন হবে শুধু ইনক্লুশন
Only inclusion
তাহলে
in the
অত
list,
কথা
my
কেন
lord.
বলছেন তাহলে শুধু ইনক্লুশন
it will be included.
And let me apply. my lord.
When you're filing these petitions, this will be included. It's a question of this court giving you permission for the inclusion.
My lord, we filed in the year like 2018. My lord, it was decided in our favor, division bench. At that point of time, learned trial court has no jurisdiction on commercial benefits.
Sir, I understand that. You file it in the registry will put it in the board.
The registry has given me the number. I am mentioning, my lord, for hearing.
Sir,
Inclusion.
Without mentioning, my lord, they will matter will not be included in my lord's list, my lord.
include karega. The registry, if they have given a number, the matter will be listed in the. Oh, let me find out from the registry.
ইনক্লুশন ইন
Mention a matter, my lord.
This is
এদিক ওদিক হয়ে যাচ্ছে
First, second, my lord, it's an examination of judgment letter. The
Yes.
judgment letter was selected to appear and also to furnish documents. It is not done.
number.
Any day convenient to your lordship, it can be pleased. But it's in the monthly list. It's there in the list.
Let it be in the monthly list.
এক্সটেনশন অফ এন্ট্রি মডেল
No urgency. No urgency. Don't mention these matters. Please.
এক্সটেনশন অফ এন্ট্রি মডেল
Extension of entry order.
My lord, the execution application running in the monthly list, my lord.
Monthly list, it's there. No urgency. Yes.
May I have the liberty to mention? My lord, one matter is not in the monthly list, my lord. May I prefer?
What is it?
Execution application.
For mentioning this is a section 14 application, I'm praying for withdrawal pursuant to a settlement arrived at. Any day convenient. On contempt application, there is non-payment of gratuity and pension, my lord, since April.
Contempt, I've got at least 30 to 40 contempts right now. Just hold on.
May I hand over the slip, my lord?
Give the slip. Give the slip. Tablet side. Just keep it.
Section.
Yes. Inclusion not right.
My lord, may I be permitted to mention one execution application, my lord? There was an appeal pending and now it is remanded, it is disposed of, it is remanded back to the section 34 court, my lord. Now the execution is to be listed.
Execution.
Earlier there was liberty has been granted to mention.
Respondent in this matter, Lordship, there was a section 37 appeal which has been directed the section 34 to be
Remanded back.
and the,
Yes.
the 34 order has been set aside, Lordship. So we will be mentioning the matter for the inclusion.
My lord, I'm mentioning for inclusion, my lord.
For the execution.
I'm mentioning.
Execution is already pending.
It is already pending, my lord. Serve the notice to me.
You have not served the notice.
I have served the notice, my lord.
At 9.
My lord. 34 application for inclusion, my lord. I am for the respondent, my lord. The execution is already pending and there will be prolonged for the 34, just we are pending on the 34 application. They are stalling my execution.
So 34 will be in the list. It must be in the running in the list. It's not in the monthly list.
For inclusion. I am for the respondent.
Take it.
My lord, at the cost of being reprimanded,
Have you informed the other side?
my lord, may I mention a matter upon notice, my lord, at the cost of being reprimanded. This is a section 34 application for inclusion. My lord, I am the respondent. I am not been allowed to enjoy the fruits of the award. I had mentioned the matter in the previous one. My lord was of the opinion.
When was the award passed?
The award was passed in 2016, June 2018, my lord. The execution, the section 34 also is from 2018. Matter fixed specially for hearing for 2 different occasions. The petitioners did not come to apprise the bylaws with respect to the 34. All they want is, since they have given a security, they want to stall the award. I am not being able to either proceed with my execution because the security is there, nor are they proceeding with the section 34 application.
Give it.
Extremely obliged. Now I'm mentioning upon notice, the notice annexed to the application for mention.
Lordship, I am praying for leave to file the appeal without the certified copy.
Not granted.
My lordship, I'm mentioning.
Not granted. No, sorry.
Fine.
No.
Your lordship, I'm mentioning the matter for withdrawal.
Give the slip.
My lordship, I am praying for inclusion in the daily list. It is arising out of arbitration order dated 10/6/2025.
No inclusion right now. Yes.
I'm humbly praying for your lordship for release of this matter, your lordship. This is section 34 application.
Release.
Yes, your lordship.
On what ground?
This is section 34 application, non-commercial, your lordship. This was heard by a previous bench, Honorable Justice Shankar Sarkar, extensively, your lordship.
Sorry, sir. No release. Till the time the order is not parted, no
It
release.
was not part of your lordship. Kindly see the ones the history.
I am sorry, sir. No release.
Lordship, may I pertinent to mention an execution application for inclusion.
Execution.
For correction of an order, Lordship, not my mistake, the vehicle number has gone wrong.
Keep it for to be mentioned tomorrow. So this आज जो लगा वो है. To be mentioned tomorrow.
Lordship, actually, without Lordship direction, matter would not be listed. If I may go to the registry said it is not possible to regularly list it. You have to mention the matter before the honorable court. That's why I am mentioning.
Let me find out.
Your lordship,
Let me find out.
your lordship, I humbly play for the inclusion of this matter in the list, your lordship. Non-commercial, section 34 application. This is not running in the list.
Non-commercial 34. Just now you said you want.
Your lordship, as your lordship has denied.
Wait now.
Item number 2, my lord, is appearing at my instance. I
Yes.
had mentioned the matter before, my lord, because I had made an error in the affidavit in support of the tabular statement. If my lord is kindly pleased to take paragraph 36 However, the tabular statement has no error, my lord. It is an error on my part. I'm seeking my lord's leave to correct. In
Para 36.
paragraph 36 at page 15, my lord.
What is the
The error is in the total amount of the due and payable to the award debtor is mentioned as 39,99,589. However, my lord, it should be
which para? This is para 13.
36, my lord, 36.
Para 36.
At page 15, my lord.
At page
15.
Yes, what is the
Sir, the total amount is mentioned as 39,99,589. However, my lord will see the table. It is the total awarded amount was 124,13,636.24. The tabular statement, my lord, contains the correct figure. It on account of my inadvertence, my lord, I have mentioned this erroneously, my lord. I am seeking my lord's leave to only correct this because my lord has directed me to serve upon them within a period of 6 weeks. Error is on my part, my lord. I humbly beseeching if I could be given leave to correct.
Shouldn't you move an application for correction?
Yes, my lord, but I had mentioned I am just seeking if
But
only
you should move an application, appropriate application for correction.
I shall since everywhere else there was a correct indication, only
But
this
still,
I shall kindly then makes the matter not today. I shall move an application at the earliest, my lord, to have this corrected.
not today.
My lord, the only difficulty is my advocate very rightly points out the client is based out of Kerala, my lord. The difficulty, I appreciate the perils of the mistake that I have done, my lord. I'm just seeking my lord's kind indulgence. If one
Learned counsel for the petitioner states that he shall be filing an appropriate application for amendment of the petition. He seeks and is granted 3 weeks time to file an appropriate application for amendment in the petition.
oblige, one page application.
No, Actually, is my application section 37 appeal?
You'll withdraw or I'll dismiss?
Yes.
You want to withdraw or I'll dismiss?
No, I'll just place a few judgments of this court as well as the honorable high courts of several high courts, because the basis of the order that was passed was unilateral appointment of an arbitrator. This court in several judgments have acknowledged this, as well as all high courts of the country. I'll place those judgments. Thereafter, Lordship will decide.
Lordship, they are challenging an interlocutory.
I know. That's why I asked him. I've been fair to him. He has not been fair to the court. So you want to argue, argue.
Is the issue, Lordship, you will kindly have...
The only issue is it's an interim order.
Yes.
Award has been passed. It is infructuous now.
I do not know, Lordship, the award has been passed.
All right, he is giving information the award has been passed.
Because there is no award has been served. If he serves me a copy of the award,
Lordship, I'll categorically state, Lordship, in the award, there has been statements and averments wherein they have stated they have received a notice. Despite that, Lordship, they have challenged the Section 17 order. Post that they have not even, they do not even know when the award was passed, Your Lordship, under Section 25 B and C, Your Lordship, the service is deemed. Your Lordship, as per Section 3 of the Arbitration Act, it is also a deemed service, Your Lordship.
I will
I'll
not
hand over a copy of the award.
Yes, let this...
All right, now you'll withdraw this?
Lordship, the issue be kept
Are you
open.
withdrawing?
Yes, the issue be kept open.
Lordship,
nothing kept open. I'll dismiss with cost, argue it.
Aye.
And I'll record your conduct. An interim order culminated in a final award and you want to challenge it.
I'll please...
And now a copy of the award has been handed over and then you want to...
No, I don't want to move it. What I'm saying is, Lordship will record
I'll dismiss with heavy cost.
I can...
50,000 for your conduct.
I can withdraw this application, but the issue with regard to...
I've told you what I want to do. Up to you. Don't do this.
Lordship, it's probably
unfairly, first he mentions the matter.
That is his fault. That is completely my fault. I bow down there without notice. There was.
And then you want to pursue this matter after the award has been
I do
passed. A
not
copy
want
of the
to
award
pursue
has
the
been handed
matter.
over to you.
Lordship, I have been received the copy. I am saying this, Lordship. You can note it down. But the only issue that why I am saying this, Lordship will only.
Fair to the court, sir.
I am not willing to argue the matter. Also, I can
Learned counsel
withdraw
for
it.
the
But
petitioner seeks to withdraw the present petition. Same is dismissed as withdrawn.
Lordship, only
Much obliged,
saying that the award has been handed over.
Award, copy of the award has been.
Yes.
Lordship, they'll revive the dead cause of action with it. They state that they'll have received the award right now.
I have not
just note
received
down.
the award.
Learned counsel for the petitioner has been made aware of the passing of the award. Though learned counsel for the respondent states that the award, they're fully aware of the award.
But the postal receipt to that effect was also.
Learned counsel for the petitioner seeks to withdraw the present writ petition. This court has not gone into any factual aspect, whether the petitioner has received the award or not received the award. Since the present petition has been filed challenging an interim order passed by the arbitral tribunal under section 17 of the Arbitration and Conciliation Act, and the final award has already been passed. The petitioner does not wish to press the present petition. The same is dismissed as withdrawn. Both.
Section 29 application, Lordship. I have served. The 6 months period, which was agreed by and between the parties, Lordship, will see the minutes at page 9 of my application.
Yes.
So learned sole arbitrator, the 6 months period ended on 8th of November 2025, the extended 6 months.
8th November.
8th November.
Okay.
It's a contested matter. Both parties know adjournments and all have been granted. Both parties contesting it, but it's taking time because a lot of witnesses are there. One of the witnesses had a major heart problem, brain stroke. That's why he had to be hospitalized for some time. It's a contested matter, Lordship. It is going on.
26 is the request to the arbitrator to now fix a date for hearing.
Page 26, Lordship, we had requested the learned arbitrator to fix another date for hearing, but the learned arbitrator said since we have to take a formal extension of
You don't have any objection to this? Okay. This court, the petition has been filed under section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal and for publication of the award. Full stop. This court, by order dated 29/7/2022, appointed a sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 11 what is the date? Pleadings were completed on?
Pleadings were completed 10th
February 2024. 24, right?
25.
25. 10 February 2025.
25.
It took 2 years to
Are
you sure?
24.
Madam, your petition says 24.
24.
10 February 2024. Full stop. By mutual consent, the mandate of the arbitral tribunal was extended for a period of 6 months.
Lordship, 1 year.
Which expired on
1 year because witness.
Extended.
No, I'm not. Which expired on 8/11/2025. Full stop. During the arbitral proceedings, certain interim orders were passed by the arbitral tribunal, which were challenged by the respondent before the Honorable Supreme Court in SLP number 5735 of 2024 and SLP number 7320 of 2024. Both were dismissed on 5/11/2024. Full stop. Thereafter, the proceedings continued and the claimant's witnesses were cross-examined on in the various sittings held by the arbitral tribunal. Full stop. Subsequently, learned counsel for the petitioner states that subsequently who fell sick?
The claimant's witness.
Claimant's witness seriously fell ill and was unable to appear before the Honorable Tribunal for 1 year to conclude the proceedings. Full stop. The learned counsel for the petitioner seeks an extension of 1 year to conclude the arbitral proceedings and for publication of the award. Full stop. The matter is currently at
Cross-examination of that witness.
the matter is currently at the stage of recording of evidence, at the evidence stage. Full stop. Learned counsel for the respondent states that she has no objection to the extension of the mandate of the tribunal. Full stop. Upon consideration of the entire record, this court is satisfied that there has been no undue or unwarranted delay on part of the arbitrator in conducting the proceedings. Full stop. Having regard to the advanced stage of the proceeding and in the interest of justice, the mandate of the arbitral tribunal is extended further for a period of 1 year from today. Full stop. The learned sole arbitrator is requested to make all reasonable endeavor to conclude the proceedings and publish the award within the extended time period. Full stop. With the above direction, the present petition is disposed of. What is your name?
Priyankar Shaha.
Shah, you are officer of the court. If you are briefing counsel,
I was not aware that he has not served. Otherwise, I would not have moved that.
Briefing counsel has not been fair in this matter.
Yes, I was not knowing all the things. That is why first I came to
You
know.
are appearing, you have the face value matters, Mr. Shah. Then the
I
court
immediately
also takes you in the same way.
Yeah, true.
You have to put an end to all this.
Absolutely.
You can't just go with the flow. First, he mentioned it incorrectly.
That is the main
Just
fault.
lied.
And 2023 it was over and he did not.
So you should at least see that.
Priyankar Shaha.
The 5, my lord, Lordship was kind enough to take up this matter on Friday. My learned friend has referred a judgment passed by this honorable court in Seri Equipment Finance Limited. Lordship was kind enough to allow us to go through the judgment and come back.
Yes.
My lord, our also, my lord, termination of mandate of arbitrator here. My lord, subject to correction, my lord, we have some reason, my lord, to distinguish that particular judgment in the fact situation of this particular case. If Lordship kindly permit me, I can show, my lord, as to why we are before this honorable court. My lord, the fag end, my lord, of these particular proceedings. My lord, the cross-examination of my witness is going on. My lord, that factual aspect need to be, my lord, elaborated if this honorable court kindly permit me, my lord. And then, my lord, I will show the law and distinguish that particular judgment. Lordship, kindly come to, my lord, page 6 of the petition before this honorable court. Page 4, my lord, I'm sorry. The arbitrator was appointed on 18th December 2023. Lordship will see, my lord, serial number, dates and particular, Roman 1, on 24th January 2024, that was the first sitting. It was held in presence of the claimant. Then, my lord, things are going on smoothly. At a point of time, Lordship was kind enough to see, my lord, initially, well, there was no problem. Lordship, kindly come to page 6. 17. Well, the time period stipulated in the act.
You are the claimant?
No, my lord, I am not the claimant. I am not the claimant initially, since there is an arbitration clause when the matter was cropped up before this honorable court in the month of December 2023. I did not raise any objection. Since arbitration clause are there, intricacies of laws and other things are not to be advanced at that point of time. We have accepted, let there be arbitrator. My counterclaim is there, my lord. My lord, that being the situation. Page 6, my lord, at the bottom, lordship will see 17 on 20th January 2025. After elapse of a year, on 12 sitting, lordship got it, my lord, page 6, 17, my lord, serial number. 12 sitting cross-examination of the claimant witness continued, and also necessary consent was given by the parties to the proceeding for extending the time limit for a further period of 6 months from the date of expiry of the initial 1-year period for publication of the award. My lord, at that point of time, when this question was, my lord, taken into consideration, we did not raise any objection. We want to cooperate. My lord, it was further extended. My lord, the period of extended time will be elapsed, will be completed, my lord, in the month of December 2025. Then, lordship, kindly see at the bottom, page 7. Lordship will see, my lord, 14/5/2025, matter adjourned at the behest of arbitrator. Turn to next page, my lord. Matter adjourned at the behest of arbitrator. Next, my lord, at the behest of arbitrator.
Before that, you also see that it has been adjourned because of you also.
Because of, my lord, my friend faced a, my lord, the accident, and as a result of which 1 or 2, my lord, they have also taken time. We did not have any objection. So far this taking time is concerned, under compulsion, my lord, this was. Then, my lord, the arbitrator, kindly see 6, 26, 27, 28. Only, my lord, on 23rd April 2005, the effective proceedings was taken into consideration by the arbitrator on 31/7/2025. That is from the serial number 29. But from 23 April to 31st July, there was no effective proceedings of arbitration. Then, my lord, 30 may kindly be looked into, prayer for adjournment. Then, my lord, 31, matter adjourned in terms of the prayer made by the respondent, which we took time, my lord. Then matter adjourned, 32, at the behest of the arbitrator. 33, adjourned at the behest of arbitrator. And communication received by the parties, whereby parties were directed to suggest few date. Lordship, I am drawing 2 paragraphs, para 9 and para 12. Page 9, the petitioner state, though the proceedings since its inception was making progress in a desirable manner until March 2025. However, subsequent to March 2025, there has been an inordinate delay towards conducting the proceeding, with only 2 effective sittings being held on April 23rd, 2025 and 31st July 2025. Then, my lord, skipping 1 or 2 paragraph, my lord, I am coming to paragraph 12. Here, my lord, the unique thing was there. Both sides remain present in the venue of the arbitration, but the arbitrator, the presiding officer, my lord, the petitioner state there were occasions wherein both the parties are made themselves available at the arbitral proceedings as directed by the learned arbitrator. However, the arbitrator chose to remain absent from attending the proceedings on the given date and time, and to the utter shock and surprise, after making a parties waited for an hour, the arbitrator over phone informed his inability to attend the proceedings for some undisclosed reason. Well, that being the situation, as a result of which we have taken the decision to move before this honorable court for change of arbitrator for delay. My lord, lordship, kindly allow me, my lord, to show, my lord, section 14. Failure or impossibility to act, my lord. May I hand over book, my lord? Yes, my lord. The mandate of an arbitrator shall terminate, and he shall be substituted by another arbitrator if he became de jure and de facto unable to perform his function. So, my lord, schedule 5, schedule 7, all these questions are there. Or for other reason fails to act without undue delay. So, my lord, we are, my lord, heavily relying upon the relevant provision of, my lord, second part of the A portion of 14, section 14, my lord, the 1, subsection 1. So, my lord, in the instant case, my lord, this delay is going on, and my lord, the arbitrator is to some extent, my lord, responsible. Now, my lord, only one question, my lord, if this honorable court was kind enough not to accept our contention and allow this arbitrator to continue this arbitration proceedings, my lord, our apprehension, my lord, maybe this apprehension now has no leg to stand upon, but we are thinking about whether this would, my lord, to some extent influence the arbitrator to take a decision which is fatal for us. Therefore, our humble submission, this apprehension, my lord, though apprehension, nothing is there to show at this juncture. If this honorable court permit this gentleman to continue and to conclude, then my lord, I have my lord, the reason to believe, though my lord, nothing to substantiate before this honorable court of law, but these things are, my lord, hunting me, that being the situation. Now, my lord, I'm coming to the judgment of this honorable court, which was, my lord, on a different aspect. Here, my lord, the arbitrator was, my lord, at a point of time, my lord, the counsel for the petitioner. On some other matter, my lord, counsel for the respondent. So, my lord, initially, it was within the knowledge of the petitioner. Petitioner agreed and accepted him as arbitrator. Subsequently, my lord, the disclosure made under section 12 that yes, I have relation, I have done work, some work, all these things, that was accepted and neglected. Then, my lord, the second aspect is, subsequently it was found that he was also, my lord, appeared some matter of respondent also. Now, the question of section 5, where reasonable belief or apprehension will, my lord, work, and section 7, where, my lord, is a schedule 7, my lord, the cast iron case, in the event it falls within section schedule 7, then he should be terminated. My lord, this is the factual aspect of this particular case. The erudite judgment passed by this honorable court, my lord, I have gone through and, my lord, enlightened myself, though this is not my, usually I am not before this honorable court, but I have learned so many things. But I think most humbly and respectfully, my lord, this is a bit different so far my factual aspect is concerned. Only our aspect is, my lord, the delay. And delay, my lord, at a point of time, my lord, I have mentioned in the paragraph 12, we are sitting there, arbitrator is not there. And I have received a telephone call, we are busy, a next date is required to be fixed. My lord, the manner and way, this is one. My lord, only one judgment I intend to rely before this honorable court. That is 2022, volume 10, Supreme Court cases 235. My lord, copy, my lord, here, section 14(1)(a), 2(1)(e), application seeking termination of the mandate of the sole arbitrator. I'm not wasting much time, my lord. I'm directly drawing lordship attention with regard to paragraph 35, 256. To do substantial justice between the parties and to ensure that respondent number 1 and 3 are not left remediless, we direct the applicant submitted by the respondent number 1 and 3 before the court concerned under section 14(2) of the 1996 Act shall stand revived. Now the court concerned before whom the applications under section 14(2) of the 1996 Act were filed shall consider the same in accordance with the law and on their own merit at the earliest and preferably within a period of 4 months from the date of receipt of the present order. It goes without saying that if ultimately it is held that the mandate of the sole arbitrator is terminated as per section 14(1)(a) of the 1996 Act, more particularly on the ground that there was undue delay on the part of arbitrator in concluding the arbitration proceedings, the arbitrator has to be substituted and fresh arbitrator has to be appointed by the following same procedure which was followed earlier while appointing the present sole arbitrator. Therefore, my lord, my prayer before this honorable court is nothing new. In the event of delay and, my lord, the willful delay, my lord, in that case one can approach the honorable court.
That's not the intent of this judgment at all, sir.
No,
it's in a different.
My lord, the delay ground, it's a ground. That is why I'm showing, my lord.
It's a ground in a different context altogether.
My lord, if that be so, my lord, my humble submission is this, my lord. Delay sometime, my lord, accepted by the honorable court to terminate the mandate of an arbitrator in the instant case may be a different factual aspect. Our humble submission, this is nothing new, my lord. As far as this domain is concerned, my lord, the arbitration mandate of the arbitrator may be, my lord, ended in the event the delay is on the face of record. Here, my lord, we have shown, my lord, the delay is there. Considering all these aspects, my lord, lordship will decide. And, my lord,
this whole case is regarding 11.5 and 11.6. Nothing to do with delay. Yes.
I'm grateful to your lordship. I'll come back to the judgment after, my lord, on facts, my lord, if I place something. My lord, the application has got, my lord, not a single allegation of, my lord, bias or any of the postulates of, my lord, 12.5, either Schedule 5 or Schedule 7. It does not come within any of the entries in the Schedule 5 or Schedule 7. So that's my, lord, first, my lord, submission. My lord, apropos your lordship's judgment of this honorable court, my lord, saying that, my lord, 14 can only be maintainable if it comes within one of, my lord, the entries under Schedule 7. Now, my lord, the second thing is that, my lord, with regard to delay, my lord, I have already, my lord, shown to your lordship, my lord, there are umpteen, my lord, decision, my lord, minutes where, my lord, they have taken time, and, my lord, they have also, my lord, sought for an adjournment even after, my lord, the period which they have, my lord, mentioned in their application, that is from, my lord, April onwards. So even, my lord, if we consider April to be the yardstick, then also, my lord, they have sought for, my lord, time. Now, my lord, interestingly, after, my lord, filing this application, according to them, my lord, they did not serve us the application, my lord, until and unless after the long vacation. So from 17th of September, just give me the dates, please. From 17th of September onwards, they have been seeking adjournment, my lord. Very merrily, my lord, being a respondent, my lord, perhaps I would have done the same thing. But, my lord, from 17th of September, my lord, they have been seeking adjournment. So, my lord, the delay question, my lord, does not arise in this case. Now, my lord, coming back to, my lord, what has been placed, my lord, yes, my lord, 17th, 10th of November, 17th of September, 10th of November, 21st of November. And next date is, my lord, tomorrow. 17th September, 10th of November, 21st of November. Long dates have been given. It's not as if, my lord, a short date has been given. Now, my lord, coming back to, my lord, section 14, my lord, once.
And they are taking adjournment on the ground that
this application is pending.
is pending.
Yes. This application is pending. And, my lord, none of the times, my lord, the witness is also coming because their witnesses are in the box, my lord. Section 14, my lord, he, my lord, relies upon the mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if he becomes de jure or de facto unable to perform his function. This has to be read with, my lord, the next portion, or for other reasons fails to act without undue delay. So, my lord, it is upon the arbitrator. If the arbitrator fails to perform or has an impossibility to perform, and due to that delay happens, and delay is also conditional, saying that undue delay, my lord, this has been, my lord, dealt with in one of the judgments of, my lord, Hyderabad, in a division bench only, my lord, as a persuasive value. If your lordship kindly looks at this, my lord. I'm going to charge. Go ahead. Lord, kindly, my lord, takes, my lord, paragraph 42 and 43. I'll not trouble your lordship, my lord. Has been dealt with. Thereafter, my lord, 14 was, my lord, finally, my lord, dismissed. But, my lord, kindly sees this. 42, my lord, dealing with the concept of undue delay and the meaning of the word de jure and de facto, and section 14(1)(a), a division bench of the court in such and such, after referring to the authorities on subject and to the dictionary meaning of the word de jure and de facto, and relying upon the judgments of such and such, observed that the incapacities referred to in section 14(1)(a) of the Arbitration Act are such to have a direct nexus with the inability of the arbitrator to perform his functions. This incapacity or disability should occur to the arbitrator himself, so that he becomes, as a matter of law or fact, unable to perform his function. The de jure impossibility referred to in section 14(1)(a) is the impossibility which occurs due to factors personal to the arbitrator, and de facto inability occurs due to factors beyond the control of the arbitrator. It has been observed that mere disability is not a condition precedent for invocation of section 14 of the Act. The de jure inability must relate to his ability to function. Insofar as usage of the word delay in section 14(1) of the Act, which relates to termination of the mandate of arbitrator, it is for other reasons fails to act without undue delay. The division bench observed that the word delay is qualified by the word undue. Undue delay and not mere delay would alone justify the court to declare the mandate of the arbitrator as terminated. The division bench held that the word undue means unjustified, unwarranted, unreasonable, excessive, and inordinate. In order to declare that the mandate of the arbitrator stands terminated, the court must be satisfied that the delay on the part of the arbitrator was unjustified, inordinate, or unwarranted. It has also been held that the court exercising jurisdiction under section 14(2) of the Act to declare that the mandate of the arbiter stands terminated, the petitioner was not only required to plead, but also to prove that the arbitrator had failed to act without undue delay. The word fail means neglect or go wrong or fall short of what is expected. What is required to plead and prove is that the arbitrator had neglected to act without excessive or inordinate delay. The division bench further held that even if there is a delay on the part of the arbitrator in completing the proceedings and to pass an order, it is open to the parties to waive their right to object. So, Mulad, because Mulad, I'm not using any affidavit to this application, Mulad, I'm trying to Mulad, go at the threshold. Mulad, I know it for a fact, Mulad, the arbitrator had Mulad, health reasons, and they also know it, Mulad. My learned friend is there in the arbitration. For health reasons, could not Mulad attend the few meetings which was cancelled. He had fallen down and he had really Mulad, hurt himself. For that reason, he was not even coming to court. My learned friend is there, Mulad, can actually personally vouch for it. I'm not using an affidavit to that effect because Mulad, there is no personal allegation of Mulad biasness. Mulad, those are my Mulad.
Yes. Take down.
Respectful submissions. But may I beseech also one thing, Mulad, it is their application. But Mulad, will it be a lordship's pleasure to Mulad extend under Mulad, because under Mulad the Mulad omnibus
Extension, you have to file it.
I'll file.
That's not the scope of this petition.
I know.
May I be permitted, my lord, for a file?
Yes,
My learned friend is here.
The petitioner has instituted the present petition under section 14 of the Arbitration and Conciliation Act 1998, seeking termination of the mandate of the learned sole arbitrator appointed to adjudicate the dispute between the parties. Full stop. The only ground on which the petitioner is seeking the termination of the arbitrator is the ground of undue delay on the part of the sole arbitrator in carrying out the proceedings. Full stop. Learned counsel for the petitioner has drawn the attention of this court to the various sittings held by the learned sole arbitrator, and in particular, he states that from (14/5/2025), the arbitrator did not. The arbitrator, despite keeping the dates for the sitting, had adjourned the matter on 3 occasions, right?
Yes.
On 14/5.
Lordship, the dates, Mulad.
14/5, 19/5,
17/9, 10/11, and 21/11.
Oh, these are when he has sought time. I'm saying the arbitrator had not held the settings.
Or not held
The-
the settings. Mulad.
On 14/5,
It's on 14/5, 19/5,
19/5,
18/6, my lord,
18/6.
and subsequent there to, my lord, on 22nd of August and 25th of August.
18/6, and further on 22nd of August and 25th of August. Full stop. It is also evident from the record that the petitioner has been seeking adjournments in the arbitration proceedings during the course of the proceedings. Full stop. The learned counsel for the respondent states that the arbitrator had suffered an injury and the said fact was duly known to the learned counsel for the petitioner, since the arbitrator was under medical advice. Full stop. The petitioner has not raised any of the grounds of bias. The only ground alleged in the petition is that the arbitrator had the arbitrator did not hold the sittings, causing undue delay in the arbitration proceedings. Full stop. This court notes that the scheme of the act does not support the contentions of the petitioner. Full stop. The full stop. Under section 14(1), the mandate of the arbitrator can be terminated only if the arbitrator becomes de jure or de facto unable to perform his functions, or for any reasons fails to act without undue delay. Full stop. The legislative guidance on what constitutes incapacity, bias, conflict of interest, or circumstances giving rise to justiciable doubts is contained in the 5th schedule and not in the 7th schedule of the Act. Full stop. The grounds urged in the present petition do not fall within any of the categories enumerated in the said schedules. Full stop. There is no allegation of bias, conflict of interest, ineligibility, incapacity, or any statutory bar attracting the 7th schedule. Full stop. Nor does the petition disclose any circumstances falling under the 5th schedule that could give rise to justiciable doubts as to the independence or impartiality of the arbitrator. Full stop. As regards the delay, the Honorable Supreme Court has consistently held that the occasional adjournments or administrative difficulties faced by an arbitrator do not by themselves constitute a legislative ground for terminating the mandate. Full stop. The section 14 contemplates that section 14 contemplates where the delay is such that the arbitrator can be said to have abandoned, refused, or become ineligible or incapable of performing or continuing with the arbitration proceedings. Full stop. A mere few adjournments, without any material indicating persistent neglect, bias, bias, incapacity to act, or a state of inability cannot be construed as failure to act. Failure to act without undue delay under section 14 of the Act. Full stop. Accordingly, in the absence of any de jure or de facto inability of the arbitrator, or any circumstances attracting the statutory schedules, the petition is devoid of any merit and is liable to be dismissed. Anything else?
No, my lord,
There's nothing more which is there. Just
I have
couple
to
of
come back to
delays.
29.
And you also know the arbitrator is a lawyer. I don't know why you have filed this application.
But that at
I
times, my
did
lord,
not want to bring that up, my lord.
Very unfortunate.
at times, my lord, it's our lacuna because the prudent
So
advice
if the
doesn't work.
arbitrator has a medical emergency, you will take dates, but he can't. And you're well aware he's a lawyer who doesn't even come to the court when he has medical emergency. Still, you file an application like this. These applications should be dismissed with cost. Next.
I'm grateful.
सबका है?
Yeah.
Next.
Lordship, I'm for the petitioner. Today, the receiver is filed.
Yes, what is the report? You have taken the possession.
The main gate was closed. I did not find any asset. And on asking one neighbor of the respondent one, who told that 2 or 3 days ago the respondent laid the plate. So I could not take it.
Yes, you have got the copy of the report.
Lordship.
Yes.
Lordship, we'll schedule the visit again if we can trace the asset. Kindly grant us time.
The report filed by the receiver is taken on record. The perusal of the report indicates that the receiver was not able to take possession of the equipment, namely hydraulic crawler excavator. excavator. Yeah, hydraulic roller excavator SY 21 OC hyphen 9 AC serial number 19 SEY 021. ये यहाँ से काट लो। ये H2 of the report. All right. Full stop. क्या लिखा है? कि
Perusal of the report, certain take possession of the equipment.
so and so due to the fact that she could not find the asset. Full stop. Learned counsel for the petitioner states that they will come up with better particulars of the asset and would request the receiver to take possession of the asset. Full stop. Then in that case, pay her again if she has to travel.
Lordship, we will do.
The where is the this asset located? Where did you travel? Okay. The mandate of the receiver is extended further to carry out the directions of this court. Filed. Order dated 11 June 2025. Full stop. The receiver shall be entitled to the how much was the earlier one? The same terms and conditions. The receiver shall be entitled to the same terms and conditions as earlier. Returnable on when do you want, madam? 6 weeks, 8 weeks?
8 weeks.
8 weeks.
Lordship, in this, the asset has been repossessed.
My lord, I am the
Receiver-
receiver in this matter. I'm filing my report, my lord.
May the receiver be directed to
To?
sell the asset by the way of private treaty.
This is item 7, huh?
Item 7.
All right. Take down the receiver. The report filed by the receiver is taken on record. Perusal of the report indicates that the asset has been possessed by the receiver. Full stop. Learned counsel for the petitioner prays for selling of the asset by public auction to recover the sale proceeds as pertain to satisfaction of the petitioner's claim. Full stop. The receiver shall take steps to sell the asset through public auction and file a further report before this court. Full stop. Before this court. So, you do this exercise, madam.
Yes.
We will pay her further for this exercise. Do you have any order where how much is generally given?
Not right now.
Hey, Gopal. कोई ऑर्डर है कितना रिसीवर को कितना अपॉइंट करते हैं? All right. I'll look for it. The receiver shall be entitled to such and such, along with all.
Lordship, 50,000.
50,000, my lord.
How much?
Last time, 50,000.
First time it was 50,000. I'll just revise it. Along with all the expenses. Eight weeks. 8 weeks.
Lordship, the receiver is yet to be paid and the asset has been traced, but we will schedule the visit very soon. We are yet to schedule because of the flight.
All right.
Grateful, your lordship.
Learned counsel for the petitioner states that petitioner that they shall be making the necessary arrangements and paying the receiver for carrying out the orders passed by this court. By an order dated 3rd November 2025. When do you want? This will take time. 8 weeks.
Grateful, your lordship.
Fine.
Your lordship, I appear for the respondents. In this, we were having a talks of settlement, your lordship. The amount due was 29,50,000, your lordship, page number 82.
Just one second. Yes, Ms. Pandey. Page
82, your lordship.
Yes.
From the bottom, your lordship, the column is there, the third row, 29,54,566 is the original amount which is due, which was payable in the month of
February 2024. Your Lordship was humbly praying that at the behest we may pay 5 lakh rupees and the remaining amount by way of an installment, Your Lordship. Because of financial crunch, Your Lordship, they could not conclude because the lawyers are not in a position to come to a
I'll
conclusion.
give you some more time
Your
to,
Lordship.
Lordship, the settlement talk did not go through. We would like to proceed with this.
So that's why I'll give you more time to explore the possibility of an amicable settlement.
Lordship.
Learned counsel for the parties state that the parties are in there are settlement talks between the parties. They are trying to resolve this dispute amicably and pray for a short adjournment. Full stop. Let this matter be listed when you want.
Your Lordship, sometime in January, Your Lordship. Meantime, we'll come.
Lordship, the receiver has the report.
What is the report?
The machines were locked, but the receiver could not locate the asset, Your Lordship.
The respondent, he is told that he gave it to third party and asset was at present at Rajasthan.
Report filed by the receiver is taken on record. Full stop. Let this matter be listed after 6 weeks, 4 weeks.
6 weeks, Your
6
Lordship,
weeks.
in January. Much obliged.
Lordship, the visit was scheduled. Receiver has filed the reports.
3rd November, madam.
Lordship, we will reschedule the visit once more. We
You-
could not trace the asset.
Not this out, my lord. I could not locate the asset, my lord. Because the respondent is
Same as
put the necessary
same as item 6 then. Same order as item 6.
information. 6.
Lordship.
The equipment is.
Submit.
Where's the report?
Report has been
Filed on 3rd November.
Yeah. Signing this one. Yeah. June 11th, 2025. Same. 8 weeks.
What do you think? 6 0. And November.
No. April. $11.
Lordship, we will reschedule the visit. In 11.
I am the receiver, my lord, in this matter. I have filed the report, my lord, 3rd November. 3rd November, I have filed the report, my lord. The asset was not located, but came to know that the asset was lying Tirupati Mandir.
They want you to again carry out the exercise.
If the asset is traceable, Lordship, we will like to schedule a visit.
So you tell me what you want.
Lordship, similar order as the last.
S6. Same order. Report already है. Order देख लेना उसे फर्स्ट पैरा पे ही लिखा हुआ है. दिखा ना? Only asset का. When were you appointed, madam?
Video order dated 8 July.
8 July. 8 July. 12.
My lord, yes, my lord. I have been appointed receiver, my lord, in this matter. This is the report, my lord. I went to the place, my lord, but I could not trace out the asset, my lord.
Yes. Same.
Matter report now.
अब रिया ये 2 और लेके जाना है। हाँ सर ये देना रिपोर्ट का एक और करके जाना 13 ये 12 when was she appointed?
My lord, I have been appointed
11th
11th June, my lord.
11 June.
In not that.
Okay. That's good. Take 13.
My lord, I am appointed
Yes.
receiver in this matter and the last date.
You got the
Yes, no,
asset?
my lord. No, my lord. I can got
What do you want?
because
Same.
the petitioner.
Same as it. When were you appointed, madam?
Yes.
When were you appointed?
7th June,
7th June.
my lord. My lord, respondent vehemently opposed.
Sorry?
Respondent vehemently opposed in this matter. The petitioner cannot arrange the police protection for heavily rainfall.
Petitioner cannot?
Arrange police. Arrange police.
could not
That they will do.
the police.
Yes, my
Order is already there. ठीक है? Now you. Thank you. What steps have you taken for constitution of the tribunal?
Lordship will file section 11.
You have already filed?
Lordship, we are
File it. This
we will be filing.
okay. You can go. Absolutely. Thank you. Yes.
14, my lord, on last occasion, my lord, on 10th November 2025, your lordship directed me to file a reply, my lord. The learned counsel, my lord, Miss Sijoni Mukherjee, my lord, appeared in this matter. He is ill, my lord, so it was not completed, my lord. Kindly grant me 2 weeks time, my lord. If
Not today, next week.
next week, my lord, 2 weeks.
Nothing is there in this petition.
Yes, no, my lord. It is section 9, my lord. I have
I know,
already paid, my lord, 25
I know,
lakhs.
I know,
my lord.
sir.
I will willing to pay, my lord, 5 lakhs, and my lord, remaining is by installment, my lord. I pay by installment, my lord.
I know what is there in the petition. Next week. Not this week.
15, I am for the petitioner, my lord.
My lord, I'm praying for a short passover, my lord.
My lord, here, my lord, the settlement talks is going on. My lord, only thing is that
My lord, my senior is engaged in another court, so I'm praying for a short.
Settlement talks are going on or not?
yes, my lord, that is the, my lord, let it be recorded that I have taken instruction. My lord, they have invoked the jurisdiction, my lord, the arbitration jurisdictions. My lord, there I have raised an objection that appointment of unilateral appointment of arbitrator. In the meantime, I have received instruction. The settlement talks is going on. It is they are exploring the full and final settlement with the with the my lord. Here, my lord, the borrower is the my lord, the partner of the partnership firm. Who is the borrower? My lord, this is a partner of the partnership firm. Now, my lord, his property, my lord, the residential house, which is my lord, under the my lord, the
The house is maintainable here. Seat of arbitration is Chennai, right?
my lord.
Seat of arbitration is Chennai.
Malad, the notice has been issued to me from here. Malad, the agreement has been signed here in Calcutta. So, Malad, everything has been written therein. And Malad, in the meantime, all the notices. And Malad, the second surface also, they have initiated Malad surface proceedings. That is Malad, the essay is pending before the Debt Recovery Tribunal, Calcutta 3. Now, my lord, that is there, my lord. So, my lord, so all these things, but my lord, so far I have instruction now, my lord, that the settlement talks is going on.
Yes,
It
madam, settlement.
can be settled, my lord, by 2 or 3 weeks. That's why, my lord, I am asking for an adjournment so that it can be settled out.
Yes, tell me.
But this is, my lord,
Any settlement talks?
I have no instruction for settlement.
but so far as, my lord, I have instruction today from my learned my junior that they have already written a letter and along with the
Let them
well,
take,
that
not today, let them take instruction.
well, only, my lord, only one line order, because that's why, my lord, unless
No
I
one line order, not today, tomorrow.
well,
Much obliged.
Get your instruction.
but then, my lord, after vacations
Why after vacation?
in the meantime, if it is, my lord, settled,
Let
that's
them come back tomorrow. We'll
fine.
see that.
I am appearing to the petitioner in this matter. Lordship, the matter has been settled between the parties. I wish to withdraw. Was the last order.
Learned counsel for the petitioner seeks to withdraw the present petition since the matter stands amicably settled between the parties. Full stop. Petition is dismissed as withdrawn. All interim orders, if any, stands vacated.
My section 34 application. This is that matter which Lordship was hearing, my lord, of the railways. She had said at 12:30. I can come back at 12:30 also. This will take time, my lord.
We can start.
Or very well. I
Both the
can. In that case, I have no issue.
Is
But as I was showing to my lord, is that, my lord, the contract arises out of my
can
lord.
I just come back in 5 minutes?
Yes, yes, of course. 5 मिनट हो गए ना चाहिए तो देखो कि देखिए
I'll be back.
একটা 15 বলছি একটা 10 তারা হ্যাঁ কন্ট্রাক্ট জাজমেন্ট বলতে জেরক্স নিয়ে
রিস্কি নিয়ে নি তবে যদি বলে হ্যাঁ
দরকার নেই
এটাই তো বলছি
কনস্ট্যান্টলি পড়ে আসছে 45 একটা 45 সেখানে
Other side, I think.
হবেই
You're also sending me. Just do that. Don't ask me mistakenly. The son is more efficient. He doesn't ask me, he just does it. Very, very good. Not bad too. So, one bad too. Supplement the actor. You're actor. What is the name? Yeah, activity. Yeah. এরকম প্রাথমিক হয়ে গেছি রাজেশের ইন্সপিরেশনে Let me start. Right? You're helping me along. মাঝে মাঝে হয় যেখানে একটা বক্স খুলে গেল আবার ওকে ডাকে "এই তুই দেখ এই বক্সটা কেন খুলে গেল এখানে?" এটা করে দেওয়া চলে যায় but I couldn't master this writing on the right hand side. I find it more convenient to write here. I find it more convenient নিচে লেখাটা লিখে মানে এটা এদিকে লিখতে গিয়ে আর মনে হয় এত এইটুকু হয়ে যাবে ওটা কোথায় কে বসে কি করে তোমার কে বসে কি করে তোমার very improved. True? Very good. Yes. তো এটি বসে বসা আছে কিরকম বসা আছে গুড মর্নিং বলো আনলেস গোপালদা এসে যদি বলে যে আমাকে দোকানে পর করতে দাও বা ওটা আমি চলে যাবো আপনি কি করে অ্যাওয়ার্ডটা এখন দেখা যাবে?
কিচ্ছু না, জাস্ট একটা ওভারভিউ। এটা কোথায় আছে প্রপোজালটা? My lord, on the last occasion,
Yes.
I gave an overview to my lord as what was to be the disputes which were referred, my lord, to the arbitrator in terms of the contract.
Yes.
Now, my lord, if I may just show from the documents, your lordship will kindly take one volume. DPR টা কই? My lord, volume 7. এটাই DPR. Volume 7, page 948, my lord. হুম।
আমার পড়াই আছে
ওপরে কোনায়।
আমাদের তো এরকম করেছিল কেটে যাচ্ছে সব।
Now, my lord, if lordship sees, this is, my lord, the proposal letter which contains thereafter the DPR. Now, this is dated, my lord, kindly sees, my lord, May 30th, 2006. At the top, my lord, right-hand side,
Yes. Yes.
my lord, kindly sees the subject, private railway siding to serve Messrs. ECL at Durga Chowk of Kharagpur Division, Southeastern Railways.
Yes.
We thank you for your cooperation for granting approval to our application for developing a private siding at Durga Chowk of Kharagpur Division of Southeastern Railways. Our consultant Messrs. Follow-up Consultancy and Liaison Services have already prepared and submitted 12 copies of the DPR to our office for further approval. In line with the same, we are sending here with a pay order number such and such for 4 lakhs and odd drawn on such and such bank. You are requested to accept the same and grant permission for approval of DPR and also give your consent to start the work for the proposed siding. Now, my lord, kindly sees the DPR, which, my lord, is thereafter followed by the agreement later on. Now, this is very important with because the DPR will speak for itself what they wanted. My lord, lordship will kindly come to page, my lord, 953. My lord, first paragraph speaks about the credentials of the company, that's the respondent. We are leaving that. Kindly comes to the second paragraph, my lord. The sentence starts, they have submitted their proposal to the Chief Operation Manager, Southeastern Railway, for setting up of a private siding at Durga Chowk Station Yard of Pashkura, Holdia section of Kharagpur Division, by a letter dated such and such, 21/2006, and they have accorded in principle approval vide by Deputy Commercial PNP's letter dated 6/2/2006. Now, my lord, what is the project? Kindly sees, this is very important because, my lord, they say their entire claim is based on this without providing or abiding by the contract. I'll demonstrate that. Under the planning of the plant to be set up near Holdia, the traffic is expected. So this expectation is given by them. So, my lord, the railways, the commercials of railways are that I am giving you a private exclusive siding for the only reason that I'm going to earn the projected, my lord, calculations that you have given me. Now, kindly seize, my lord, the outward traffic in 2006-2007, according to them, would be, my lord, number of wrecks would be 120. And I will show, my lord, not a single wreck had come. And they have got an award for 243 crores and odd as compensation and as damages. Although, my lord, the breach is from their end. So I'll show, my lord, how perverse the award is. That is why I'm showing, my lord, my lord, what was projected, what was the contract, and what is the award. Now, kindly see, my lord, their projection of 2006-2007 is 120 wrecks with a quantity of, my lord, 360,000 metric ton per annum. My lord, this increases. Lord, she will see the volume increases. By the time, my lord, it comes to 2009-10, their projection is, my lord, 135 wrecks,
Yes.
which is huge. Then, my lord, kindly sees the inward traffic. My lord, the inward traffic would be from 2006-7, they project around 140. Then, my lord, they come down to, or they go up to rather, my lord, 2009-10 to 155, my lord, wrecks, with a capacity of 465,000 metric ton, my lord, per annum. Now, my lord, kindly sees, it may be observed that there would be phenomenal growth both for inward and outward traffic to be offered, my lord, kindly sees, to be offered by Electro Steel Casting Limited, that's the, my lord, respondent before, my lord, from the KGP division through their siding as mentioned above in the year to come, and the consequential increase in revenue to the railway. So the projection is, my lord, this would only increase
Yes.
and never be a zero.
Yes.
So the lower limit, my lord, he says, would be achieved, it would go up and up and up. And, my lord, this would increase the revenue to the railways. Now, my lord, kindly sees, railway transport clearance for the railway transportation clearance application has been submitted, which is expected to be accordance within the short time. Now, my lord, kindly sees thereafter, kindly comes to 958, my lord. Because the entirety is not required, my lord, kindly comes to 958. Now, kindly sees, my lord, what is the work that they are going to do in order to, my lord, get me this revenue. My lord, 1.1. Before that, again, my lord, it's about their credentials. The company wants to set up a private siding at Durgachok station for export-import of raw materials, finished goods through Holdia port. Now, my lord, on the last occasion, I told, my lord, I'll show also as I, my lord, will be going through my arguments, that the understanding was then in India that, my lord, interstate coal could have been transferred. But I could get coal from Bihar, processed it here, and again sell it to Rajasthan. So for this purpose, my lord, they needed a private siding. So, my lord, they needed a private siding. I can't give them, my lord, exclusively. So they said, my lord, it would be to your help also, because these number of wrecks as it is of mine would come, and then others can also come in, and, my lord, you can earn out of it. And the freight would be what I would earn, my lord, from the wrecks. Now, kindly sees, my lord, what happens, as I showed, my lord, later on, the government of India came up with a notification that this interstate coal transportation is prohibited. It won't be allowed. Now, my lord, for that, I cannot be saddled with the cost of their business being coming to a halt. But I'll show the arbitrator never ever considers that. Does not consider even the, my lord, notification of the Union of India, which is passed by the Union of India as a policy decision. Now, kindly see, my lord, the company wants to set up a private siding for export import of, then, my lord, for this development, the provision of a properly to set up a railway private siding is inescapable for economic handling of heavy incoming and outgoing consignments. The company, next page, my lord, 959, approached the railways. So, my lord, I did not, my lord, invite them. It's not a tender that I invited them. The company approached the railways by their letter mentioned earlier, expressing their desire to set up a private siding at Durga Chowk station yard, the nearest suitable location from the Haldia port, because that's the place from where the coal is to come or to be exported. The Southeastern Railway held discussions with the company. Southeastern Railway advised the company about the norms and forms, my lord, because I'll show, my lord, notifications which clearly, my lord, is engraved in the agreement entered upon between the parties, which says that if you set up something and if you, my lord, incur a loss or if you go away or terminate, you have no right to claim damages. Again, my lord, I'll show completely ignored by the arbitrator. And my lord, damages without evidence has been allowed of not 1 lakh or 2 lakh, but for crores, my lord, close to, my lord, 100 crores. Now, my lord, kindly sees about advise the company about the norms and forms for setting up of a private siding. So I give him the, my lord, clear instructions that it would be in terms of the government notifications. According to the recommendations and suggestions of railway authorities, a course of action was followed both at administrative level as well as technical side. The company appointed such and such, my lord, this was appointed by them, my lord, as a liaison, my lord, and a consultant. Now, my lord, kindly sees the work is targeted to complete within 3 months. This is the most important factor. They were not able to complete it, my lord, after even 8 years. And this is their projection. The work is to complete within 3 months. And only thing that I needed to give them, my lord, was the land.
Yes.
To the base of I think this should be the best, my lord. To the best of the above discussion, such and such submitted a report after obtaining principal approval from such and such, all works to furnish the detailed project report. Now, my lord, as the first step of preparation of DPR, survey team conducted the survey works in details at the site of Durga Chowk station yard in the first week of February 2006 to find out every aspect of the site to have the best feasibility for the siding and have well knowledge about the works to be executed after approval of DPR. So, my lord, it is their statement that they say that they have made an inspection, conducted a survey, and to their best feasibility, my lord, the siding is, my lord, according to their knowledge, and it is, my lord, only awaiting an approval of the DPR. But there is no evidence to show. I will, my lord, later on show to my lord from the evidence itself. That is why I wanted to bring in the evidence before my lord. That, my lord, what happened that within 3 months after getting all this, they couldn't complete. Even after 8 years, they couldn't complete, but they were entitled to, my lord, a compensation for not completion. Based on the detailed survey and sees drawing number such and such, Durga Chowk station yard is station, a detailed layout plan is prepared showing the proposal of the private siding, which is considered by Electrosteel as best feasible and walkable proposal. So they accepted, my lord, that this was the best feasible and walkable proposal. Now, my lord, the acknowledgement is provided. Now, my lord, kindly comes to requirements at page 961. 2.1, my lord. The company proposes to enhance its production at different units and at different places, as well as speed up its receiving and dispatching capacity of the raw materials and finished goods. To meet the greatly increased incoming and outgoing loads, the firm wants to avail easiest transportation system, which could only be economically done by railway. Transportation provisions with the setting up a railway siding at Durga Chowk station yard. The provision of a railway siding is also inevitable for the different shape and size of finished goods of the unit. Now, my lord, this is again very important. What is our income? What I am going to earn? The inward and outward monthly traffic at Durga Chowk siding will be as follows. Inward traffic was 10 rakes and outward traffic was 12 rakes. This is what they suggest per month. And I would show it is zero. It was zero. Engine on load is also possible in the proposed layout if required, which enable quick disposal of outward finished goods and receive inward raw materials. Now, my lord, kindly comes to next page. Kindly sees their projection and what they, my lord, propose, which was accepted. 3.1. Since 22 rakes per month would have to be dealt with, it would mean that on an average, 3/4 rake to be handled on the siding per day. The Southeastern Railway has agreed the engine on load with the brake van on the siding of Messrs ECL. After dropping the road, the rakes can be loaded with finished goods or may return empty. The handling system within Messrs ECL siding would be of any convenience means to enable unloading of the loading wagons and vice versa within the permissible free time so that there should not be any demurrage accrued. Now, my lord, kindly comes to commercials, my lord, which is at 963, 3.7. My lord, the last paragraph at 963. 3.7.1. The booking point of the siding will be ECL and the formalities of booking with full payment for provision of a booking clerk will be maintained by ECL. Therefore, my lord, the entirety of the, my lord, project was in their hands. I was only to provide the land and to get my revenue under the projections made by them. The total length of the line would be standard length of foot length in Durga Chowk yard for the purposes of booking of consignment. Now, my lord, kindly comes to 3.7.4, the last one. The payment of freight will be as per the present system of the Indian Railways. So the rates were, my lord, unilateral, which was being followed by the Indian Railways. Now, my lord, kindly comes to 964, 3.8.2. A separate siding agreement will be executed as soon as the construction of the siding is completed and a fit certificate is issued by the railway authorities for movement of railway traffic. No construction was made, my lord, admitted situation even till today and on the day that the award was passed. No construction was made. It says, as soon as the construction of siding is completed. So therefore, my lord, all that the, my lord, arbitrator had to look into, even, my lord, a physical inspection could have been made by him, that whether the construction is completed or not. After 9 years even, my lord, there was no completion of the construction, no fit certificate issued by the railway authorities. We requested, I'll show, my lord, we requested time and again for commissioning. They, my lord, did not do the commissioning. They, in fact, refuted and they, my lord, raised, my lord, disputes. So, my lord, if the project as made by them is not concluded by them, my lord, not, my lord, initiated by them, because none of the rakes came in. My lord, where is the question of damages and compensation coming in as far as breach is concerned? Breach is from their end. Now, my lord, kindly comes to the letter which was given by them. My lord, this is in volume 244. কেনাই হয়েছে, দুটো পড়ে আছে দাদা, কিন্তু করতে পারিনি, আমার ভীষণ অসুবিধা হয়, ভীষণ অসুবিধা।
What happened, Mr.
Mr. Sen was saying
Now,
that
the
why
inquiry that
haven't
Rising Star, why has he not shifted to the iPad?
Rising Star? I feel very
It's following us.
Yes. But I feel very comfortable with the my lord brief. I don't know why, my lord. I may be
Did you
little
try
old,
it? It's
old fashioned, my lord.
very addictive.
Very addictive.
Addictive and
very helpful.
yes, it's
You know,
more
it
easier.
makes your life easy.
But my lord,
like in Delhi High Court, we had those webcoms, and it's so helpful. I can't. You can have multiple windows. You can have all these entire, and the bookmark is so helpful that your efficiency goes way high.
but I find, my lord, in Delhi High Court, I often see nowadays, my lord, they have two screens, I believe, before the honorable judge, my lord.
Have this
Yes, big one, and the other one, my lord, on the side.
The side one is
For
the
our appearance and
yeah,
on, but
appearance and all. But the big screen has
that's divided.
multiple.
Oh,
we
because
have
I find, my lord, when I am submitting on my learned other side, my lord, the honorable judge can see both. Yes,
I can see
and even the orders, my lord.
I can see orders.
Orders, yes.
I can see your petition, his petition, and trial court records.
I was a little surprised for the first time when I was arguing that, my lord, the honorable judge was, my lord, saying the orders instantly. We were trying to find out
we have
because there is a window, I think, open for that.
We have bookmark, which makes your life very easy. So you have a bookmark for all the orders. You have a bookmark for the statement of claim. Then if there's a counter claim, and then responses, affidavits, everything is bookmarked.
Is there a dedicated staff for this maintaining the entire system, my lord?
Completely. We have
For every court.
Every court.
Oh,
I mean, this is all outsourced. So the persons who are doing the scanning, they are the ones who are doing the bookmarking too. And now you also have the trial court records.
Oh, trial court records.
Complete trial court record.
So there is no
Which pagination now?
So there is
Initially,
no
they didn't-
question of, my lord, sending a special messenger and getting the records from the lower courts.
We can do that, but most of them now
Yes.
the trial court record is there with the file. And like here, you file it without all the.
Yes,
techniques
we had
and
to
everything.
take supplementary affidavit and file.
There, you can't file it without that. Filing and the registry is very
Difficult to get an adjournment there. Very difficult. Very difficult. For the other way around in Cuttack High Court, it is even more difficult because, my lord, I found, my lord, somebody asking, my lord, that the papers were not there. So the honorable judge from the top said that the screen is in front of you. Click on your cause title, every paper would be in front of you. There, we don't have to carry an iPad even. Because that's also, my lord, on the big screen in front of you, separate for the petitioner and the respondent.
like in your OneNote, you can drag everything and put it.
Yes, yes.
So while you're dictating a judgment or order, it is extremely convenient. You don't have to go back and forth. With pages, you go back and
Yes, that also is not required.
forth. That's what he is hinting at.
I'm saying, Maharaj, then that screen.
In outstation matters, it helps a lot.
Yes.
Earlier we used to carry bags and bags of books and papers.
Correct.
Arbitrations, 30, 40 volumes of compilations, spiral bound. And now we just one iPad.
Please, in the filing section here, you scan it and give it to them.
Yes, yes.
Okay.
But I don't think that helps because lordship doesn't have a screen in front of my lord.
But
So
we
it
are
doesn't
trying.
make.
We few courts we want to make it digital
I
court.
think it started, no? It started with Justice Moushumi Bhattacharya trial period. Thereafter, my lord, I have not seen any court using it.
Because you have to have the documents scanned.
Yes,
Unless
everything.
until you have the scanned documents, you can't really. Maybe the initial filing, I mean, this has been introduced recently, I guess, so.
I think during COVID times.
Those cases you can have, but the earlier ones, like I'm hearing 34 petitions which are like 2012, 13.
Most of them are moth-eaten, eaten by ants. White ants,
But
lordship.
my lord, I'm
Lab
sure
is
in
full of white ants.
I'm sure in Delhi this was also the case. They must have got them scanned, my lord.
Yes.
Must have.
Yes.
So
All
this can be done here also, my lord. It's not that it can't be done.
It can be.
I'm sure there also pending matters were there of 2012 and 11.
Absolutely.
The odd call scanned, my lord.
All scanned.
I'm in Delhi we gave hard copies, my lord. Usually we give nowadays of the judgments, but in Odisha High Court they ask for a pen drive, so they just put in so that it can be shared across the, my lord, platform, my lord. But
judgments generally are given across the.
Yes, the Bombay, my lord, had this screen long back. They started off long back with the screen, but I never knew, my lord, it has compartments like that.
Very helpful.
Very helpful, my lord.
Very helpful.
Now I know, my lord, how does the honorable judge knows the orders so fast.
Because you can
Yes.
multiple windows.
Yes,
That's right. Yes.
my lord, kindly sees, my lord, volume volume 2, my lord, page 242. ये उल्टे है लोग, मेरे भी है। এটা 242, হ্যাঁ, এটা 101 তো।
So half the pages are this side, half the pages
Oh my
are that
God.
side. So I'll keep changing it like this and this. Which
এ বাবা, how did it get filed, my lord? I don't know, my lord. I thought it's mine only.
no, it's not. Say.
The file হলো কি করে? Or I'll file a fresh one, my lord. I'll
No,
file it.
That's
242, if your lordship takes, my lord. My lord, this is a letter that they had given, my lord, before filing the DPR, which I was reading before, my lord. January 20th, 2006. Lordship sees the date. My lord, written to us, kindly sees, my lord, propose private siding of Durga Chowk railway station to serve Messrs. Electro Steel for movement of coal and iron ore. My lord, this is exactly what was stopped by the government of India. We, Messrs. Electro Steel Castings Limited, a long-standing organization producing ductile iron pipes, we have already extended our activities to coke oven plant at Haldia, that mining at Purbatpur. We are being given right for iron ore mining at Kodilabad deposit near Bolani Kiribura area. এটা কোন রাজ্যে? An integrated steel plant close to our coal mines near Talgoria railway station, Southeastern Railway, which will also be the end use of the iron ore, is on the anvil. We have our own siding at Shodhpur. We have applied separately for our private siding at Talgoria. We hereby submit our application for a siding at Durga Chowk near Haldia, where we will construct our private siding. 2 copies of the concept plan for the proposed siding of Durga Chowk railway station is enclosed along with all relevant technical write-ups. And, my lord, thereafter the name of the consultant. So by this letter, my lord, they, my lord, proposed to set up a private siding, and, my lord, wanted our clearance to do so. Now, my lord, after this, kindly takes, my lord, 244. 244, my lord, which is, my lord, our letter dated 6th of February 2006 to their general manager, my lord. Your letter dated 21/2006, preliminary project report for developing private railway siding to serve Messrs. Electro Steel at Durga Chowk station between Pashkura, Holdia section of Kharagpur division, submitted with the letter under reference is approved in principle, subject to the stipulations as indicated below. The formalities for the construction of the proposed siding would follow Railway Board's letter of 1993, 22/3/1993 and 7/6/1994, and I'll show that, my lord, this was followed and they did not comply with the same. Railway transport clearance for the projected tariff to be dealt at the siding is to be obtained from the Director Transport Planning Railway Board. So, my lord, all that we rely upon, my lord, is their projected tariff. You are requested to submit 12 copies of the project report. Now, my lord, that was filed by them. After this, my lord, kindly takes page 245. Now, my lord, I am very sorry. I think, my lord, it has to be turned around. This is really difficult, my lord.
This is slightly
No, my lord,
difficult.
I understand lordship is marking also.
Can you carry out this exercise so that it becomes easier for us?
Yes, I can, my lord. I can come back tomorrow. It's if your lordship permits me to file it today, I can come back today. ওগুলো দেখে নিন। Your lordship, my lord, just grant us leave to check it up, my lord.
Yes.
I can come back tomorrow itself, my lord. Because I have to rely on these documents. ঠিক আছে, পরশু কত তারিখ? 9 তারিখ, 10, ঠিক আছে, হ্যাঁ 10 তারিখ আছে, যদি যাইও।
It is noted that the pages in volume 2 have been put upside down. Learned counsel for the petitioner.
অনেকগুলো ভলিউম আছে, 9টা ভলিউম আছে।
shall file a fresh, shall carry out the necessary exercise
I will.
by filing afresh.
রঞ্জন রঞ্জনদাকে আমি বলে দিলাম আমরা তো হ্যাপিলি এটা ভুল হলো তাহলে বলি
Liberty granted to file afresh. Full stop. Just, I think.
I will, my lord. I am extremely sorry, my lord. I was not aware of this, my lord. I thought that I am the only sufferer, but it has been, my lord, given to my lord also. I never knew, my lord.
Luckily, we can rotate our pages.
Yes.
Very difficult, you know.
No, my lord. I
On the iPad, we
understand.
can rotate.
And my lord, there are voluminous documents. I'll do it, my lord. Can we come back here, my lord?
The day after tomorrow, my lord?
He has some problem tomorrow, day after. But only one thing I must request, my lord. The next matter is Mr. Bachawat.
Yes.
Both of us gave him the impression that it would go on till 1:15. My lord, I think, my lord,
He had
little
asked us.
past.
We had
Yes,
told him
yes,
that
my
we
lord,
will go.
kindly consider.
He's not
Next
here.
matter was only his, my lord.
That's item 20.
18, I think,
18.
my lord. 18. My lord.
My lord, I was led by Mr. Bachawat. He's on his way, my lord.
Wait.
I appeal to the petitioner. I can wait.
You can start.
Yes.
My lord, I am extremely sorry for
No
this, my
problem.
lord. I'll come back. Read.
Cost. Heavy cost should be. Heavy cost.
You're for the petitioner.
Yes. 18. This is my.
You're being led.
I'm being led by Mr. Bachawat. I'm for the respondent.
You're doing it.
Yes. I am for the petition, my lord. This is my application for stay of operation of an award dated 9 December 2012.
Yes.
My lord, the awarded sum was rupees 1 crore.
It's a very old award of
Yes.
2013.
The section 34 is still pending.
31st still pending. So we should hear all the all of
Yes,
the.
my lord may dispose of the section 34 because we have filed for execution of the award, my lord.
Yes. So in the meantime, till the 34 is heard, my lord will kindly consider this application for stay on such terms as my lord deems fit. Because as per my calculation, the principal plus interest as on 28 November comes to around 2 crores 72 lakhs 27,000 and odd. And if my lord permits me to secure this sum by way of a bank guarantee, I can file the bank guarantee.
My lord, some cash, some bank guarantee. 50%, that's it. It's offering bank guarantee for 2
So, but why not finish it? What is the point of
We are
keeping it?
agreeable.
I am agreeable to finish. 34, I am agreeable to finish. They want stay of operation of the award. So that
I know, but the award is 2013. This will, if I stay,
they have to take steps. 34 is there, 34.
No, it's ready for hearing.
After it, just because of the limitation issue, we had to file the execution proceeding. And now they have applied for stay of operation.
Obviously, they will apply for it, but let this matter be listed with the 34. We'll have it together both.
Well, then may it appear after a fortnight? We'll get ready in the 34.
Whenever you want.
We are, in fact, my instruction is that they can, I leave it to your lordship's convenience.
No, whenever. Why fortnight? Why so much time?
Well, it's a 12-year-old award. We have also.
So that's why you want to finish it.
We are ready.
The whole idea is because it's 12 years old.
I appreciate, my lord.
At least 13 award should not be.
Just give us some time to get ready in the 34, my lord.
Next week? Next week you can have it. Ask Mr. Bachawat if
He's on the way.
take down. This is an application filed by the petitioner under section 36(2) of the Arbitration and Conciliation Act 1996, whereby seeking stay of the implementation of the arbitral award dated 9th December 2012, right?
2012.
9th December 2012, passed by the arbitral tribunal in ICA /28/AC/1779 bracket AD number 9 of 2011. Full stop. It is the learned counsel for the petitioner submits that the said arbitral award has been challenged in AP number
237 of 2013.
237 of 2013. Full stop. However, during the pendency of the said proceeding, the respondent initiated ECCOM. What is the number?
501 of 2024.
501 of 2024. Full stop. So that is the reason he has filed this. In view thereof, the petitioner has preferred the present application. Full stop. Since the award in the present case is of the year 2012, and the petition's challenge to the said award being AP 237 of 2013 has been pending consideration in this court for a considerable time. This court deems it appropriate to hear the final hearing of AP 237 of 2013. Full stop. Let the present matter be listed along with AP 237 of 2013 and ECCOM 501 of.
A small issue may arise.
So Chawat, what I consider doing is, since it's 2012 award, the AP is 2013. It's a long pending one. Let's finish it off.
No doubt, but not your lordship has seen nowadays. Not courts impose a condition, the lordship can finish it. But in the meantime, secure it. I'm not taking the money away, but it's now obligatory to secure it irrespective.
You can, if you want, I can ask them. Then you know what will happen. I'll just decide the entire issue.
The lordship will do that. No difficulty.
So
but
I'll
let
keep
them also secure it in the meantime. But
if
I
they
tell you,
secure it, then they will say
lordship
keep
will
it after. If I allow that, I can pass that order, the general order 36-2 order. They'll deposit cash secured.
But I'll tell you,
It will
lordship,
go
your
for
lordship will
another.
not mind my saying this, but there's many a not slip between the cup and the lip. But we've tried so hard to have two other of these identical matters heard, and my lord, it's taken 3 to 4 years. Ultimately, not out of embarrassment because we are briefed by outstation advocates. Not we also had to say we.
No, that's what I've actually. You were not
But,
here.
let me take that instruction.
You
Give
have
me
not.
one moment.
No, I'll just tell you what order I've recorded. Just read it out.
Consent the certificate. You want that heard?
Just read it out loudly, slightly loud. Stay of the operation of the award dated so and so. Two 37 of 2013.
50.
501. Yes, taking it wrong. Since the award is of 2013, I have stated that you keep all these matters together and we.
But I'll just tell you, the objection I have in principle. But the
No,
object
then I'll
is to.
still allow the application, then they'll secure it. If
Just
that
give
is
me
what
one
you want.
moment. No, Lord, I'm just trying to give some reason here, which is this. Not the object is that the money comes into court so that in the next round I don't have to go hunting for that money. It remains in court. This is the object. But please give me one moment. I'll see. Not.
If I may indicate, one small issue I have no problem with this order, my lord, discussed. But the AP that was filed in 2013 in the ordinary division, that has to be transferred to the commercial division before all the matters can be listed. Possibly, my lord. This small issue may arise. In 2013, there was no commercial division. That matter has to be transferred to the commercial division before all these matters can be listed together. Possibly.
In that case, security will have to be granted. Please see two paras of his petition. Para 34, 35, 36. He said what is the amount, which is the amount which needs to be secured. All of that is stated. He has already given it.
Yes.
There is no calculation to be done. Please see para 35 and 36. So, according to him,
Yes.
2 crore 62 is the amount under the award. He adds interest on that and he arrives at the figure as 2 crore 72. That's in para 36. And he's asking that your lordship will, not in para 39, your lordship passes not necessary orders, not for stay. In that case, direct this amount to
deposit the cash.
My lord, on instructions I submit, if my lord kindly considers permitting me to file a bank guarantee.
Bank guarantee
The
will
rule
not.
is not if at all. I'll just be reasonable here. Not the rule as far as we are now seeing across judgments.
Cash
50% cash, 50%
50%.
bank guarantee, if at all. Government organizations normally want to put in cash because interest otherwise runs.
All right.
As per my lord's direction, because my instructions were to seek for a bank guarantee.
No,
but
full bank
whatever my lord
guarantee is not going to happen. Strike down, take down. The petitioner has preferred the present application under section 36(2) of the Arbitration and Conciliation Act, seeking stay of the award dated. It's 9th, right? What is the date?
Yes, 9th December 2012.
9th December 2012. Full stop. Learned counsel for the petitioner state that he has already filed section 34 AP 273
237
237
of 2013.
2013. Full stop. Let the petitioner deposit an amount of rupees. How much is that?
2 crore 72 lakhs.
2 crore 72 lakhs 27,405. By way of cash deposit with the registrar original side, right? Registrar original side in a interest bearing FDR to be maintained with a nationalized bank. Full stop. Subject to the within a period of
4 weeks.
Within a period of 4 weeks. Subject to the petitioner complying with the above direction, there shall be a stay of the operation of the impugned award ऊपर लिखवाया ना 9th December 2012. Full stop. Then what do you want?
On failure to put in the security, the interim order will stand vacated, and my lord, liberty is given to me to apply for withdrawal if permitted in accordance with law.
That liberty you always have. You can move an appropriate application for that. In case the petitioner fails to abide by the directions passed by the court, the interim order shall stand vacated.
Deeply.
Yes, this one is first.
Deeply.
The final hearing then is
Let's do the
But
final
your lordship
hearing.
will let the security come in, we'll apply for final hearing. Let the money come in. But that's usually the principal object, not in these matters. First, have the money deposited so that if I win at the next round, I can get the money. That's the real object of 36. Otherwise, it's another 10 years back.
The real object is to finish off the matter.
But these matters, from what I've seen, please again don't.
Then you are not seeing my court.
My lord.
Then you're not seeing my court.
Right. No, we'll be very happy to have the matter heard. We'll be very happy. He's raised this technical issue that
We are
it's
taking
a
up
commercial.
34. We are taking up 34th and finishing 34th.
Commercial. Give me one moment.
The pending suits, the 2013 filing.
But the difficulty is because these are in two different divisions.
And
that's the technical problem my learned friend had raised. That's why I said we can take care of that.
I have no problem in getting the matter heard.
No, that technical problem, then you have to take care of the technical problem.
But let him take care of the technical problem. We'll come and mention it before your lordships thereafter.
All right.
Good. Obliged.
Lordship, I appear on behalf of the respondent. Lordship, kindly excuse me for appearing virtually. There is some personal inconvenience today.
Lordship, I appear on behalf of the petitioner. I am led by Mr. HON'BLE. I am praying for a day's accommodation. Today he is indisposed. Lordship, I just like to indicate one thing. This matter is a section 36 application. The section 34 has been filed. It is pending for admission in the admission stage. If it can be tagged together.
No, we'll hear it separately.
36-2 is a separate footing, my lord.
Yes. If your lordship so.
Not today, not today.
I'm so grateful.
Lord, 20 is my application under section 9. Lord, there is a subsisting Lord interim order which says that this order will run until further orders, restraining Lord the respondent from alienating a bungalow in Greater Kailash 2 in Delhi. And the Lord claim is 102 crores. But Lord, the bungalow is only worth about 45 crores. So Lord, the arbitral tribunal has been constituted. Lord, in fact, the first sitting took place day before yesterday. And the next sitting, my lord, is on the 28th of March. So, my lord, if your lordship may consider, my lord, making this, and this asset was the secured asset.
The tribunal is there now.
Yes, my lord. So, my lord, kindly consider, my lord, making this order, my lord, absolute, and my lord, give us liberty, my lord, to, my lord, press for other reliefs.
Can't be absolute. Can't be absolute.
No.
Yeah, absolute.
My lord, for a my lord,
yes,
reasonable
month or 2 months. Yes, that.
My lord, the next sitting is on the 28th of March.
I'll extend it and send it before the arbitrator.
Very well, my lord. But there are other prayers also in my 9 because one of the other assets. Kindly, my lord, leave it the window open for me, my lord, to press those prayers before the learned arbitrator. That is all. Like their fixed deposits was 52 crores.
Whatever the law, provides, they will do it.
So, my lord, it may, my lord, because those prayers are there in the 9, my lord.
Whatever it is.
Your lordship may just kindly clarify that I'll be at liberty to
clarify anything. Why should I clarify it? You always have the liberty. There's no order.
Always have the liberty. I can't take the point of res judicata. No, that can't be. That can. Today we are aware of section 9, section 17, how it works.
My lord, the claim is, my lord, 102 crores.
Whatever.
The secured asset is only worth 45 crores.
This shall be treated as a, I'll extend the.
Yes, before that.
And he can file it.
He can file open to anything. It is subject to the pleadings made before the
section 17.
Kindly, kindly just give me that liberty to pray for the same prayers which are in my 9.
No.
Again, my lord,
otherwise all points kept open. Liberty is given the extra mileage. Whatever. All points are kept open.
All points are kept open.
Yeah.
Learned counsel for the petitioner states that the arbitral tribunal has been constituted. Full stop. The
25th June order.
On 25th June.
Yeah. As separately.
May I hand over a copy to your lordship?
Para 8.
para 8 and para 9.
না না এটা কনস্টিটিউশন অফ দ্য ট্রাইব্যুনাল হ্যাঁ
All points skipped.
He's going to extend it for a reasonable period, this order, and leave everything open to the arbitrator. He's not making an absolute until pendency of the arbitration. He's saying that's on the scope of that.
The interim order granted earlier by this court, by its order dated 25th June 2025, is further extended for a period of
2 months, man. It is 28th March to 28th
With
March.
Dayek put it out.
No,
You can
make
file
that
section 17 in the meantime. Na?
for a period of 8 weeks.
Well, your lordship will
to
direct the same
enable.
section 9 to be treated as an application under section 7.
No.
No, because
That can be done actually.
otherwise we'll be repeating ourselves again.
I think that can be done.
Yes,
I think Mr.
Yes, Mr. Shah's application, if he wants, I should
Yes,
come.
because
Because we have used opposition. We have used opposition.
affidavits are complete, that matter may be taken up for consideration. Otherwise, again, filing of pleadings, 2 months will go just like that.
That's a fair thing, I guess. Mr. Shah, that's permissible.
Yes, I understand.
And your lordships regularly permit this.
That's what I also thought, that 9 will be treated as 17.
7.
Calicut. For a period of 8 weeks to enable the petitioner. Then I'll remodify it. So it's extended further for a period of 8 weeks. Full stop. Let this application, section 9 application, be treated as a section 17 application before the learned arbitrator for appropriate proceedings.
I'm good.
Full stop. With the
My opposition is also record, but
Yes,
we can also use that.
section 9 obviously with
The pleading, the other the pleadings.
with the above direction, the present
I'm very
Grateful.
petition is disposed of.
It is appears still.
Fine. Okay. My lord, may I also be, may the affidavit in reply also, my lord, be taken on record?
Hey, affidavit and reply.
So that pleadings stand completed then, my lord, before your lordship only. We've served
You'll be filing it there. Why are you filing it here?
Serve
Those you'll be filing it there only.
Serve
There
karo.
is no need for this.
No, my lord, it has been affirmed to be filed before your lordship.
No, but there's no need now.
Very well. We'll file it before the learned arbitrator. Very well, my lord. We'll file it before the learned arbitrator.
But I appear for the respondent, my lord.
But I am appearing for the petitioners in items number 21 to 23. My lord, I'm in some difficulty today. I have a matter before the Honorable Supreme Court, and it has been kept back for tomorrow. If it can be any date, my lord, later this week or at your lordship's convenience. But today and tomorrow I have some difficulty. Praying for an accommodation.
All right.
Any date lordship gives, I have no issues, my lord.
Not
to
today.
argue out the matter, my lord.
This is what he has filed. What? It's a fresh.
It's a
Section
section
34.
34, my lord. All documents are filed.
All right.
The pleadings are also complete. We didn't file a opposition because, my lord, we think, my lord, 34 should be heard out, my lord, with the records. So lordship fixes any day, my lord, we'll come back.
Not today. After 2 days.
Grateful, man.
Or 11th, I have some problem.
When
Kindly
you-
keeps it on Monday, my lord. Monday, my
Next
lord.
month.
Grateful, man.
Or kindly, if an one-liner is passed for my juniors, my lord.
Learned counsel for the petitioner states that he's in some personal difficulty and prays for a short adjournment. Let this matter be listed on Monday.
Yes. All three, man. Great.
May I please, Millets, I am appearing in 24 Millets for the award holder. My lords have kept this matter for today for them to comply with the award and to deposit the money in court.
Milord, your lordship, Milord, directed Milord us to take instruction, Milord, as to where Milord we can secure the amount as Milord mentioned in the award. Milord, I have taken instruction, Milord. Milord, let it be an order of the court. Milord, by 4 weeks, Milord, we shall do that. 50%, Milord, in cash, Milord, 50%.
Millets, the total amount is more than 1 crores as
lakhs
on
in the award
the filing of the 36, which we have mentioned 1 crore 2 lakhs at page number 13 of my section 36 application. Page 13, para 31.
Para, sorry?
30, para 31, page 13. We have mentioned it at 1 crore 32,984.
Milord, the awarded sum is 50 lakhs. If your
Along
lordship,
with interest of 12.5%. That's the total amount which is coming, my lords, on the date of filing of this matter. Let the amount be
We
deposited.
filed an affidavit of asset and all here.
no, Milord, we have not filed. That is why, Milord, on the previous occasion, we prayed for an accommodation to file my affidavit of asset.
Well, let them deposit the money. There's a criminal case also going against them. If in 2 weeks or if they could
Deposit the money at least.
Milord, I tell your lordship, Milord, Milord, in the meantime, Milord, kindly direct us, Milord, to file our affidavit of assets. Milord, we have filed 34. Milord,
Then I'll attach your bank account.
Yes.
Then I'll attach your bank account.
Milord, we shall secure the amount, Milord. I tell your lordship, Milord, within 4 weeks, Milord, we shall secure the amount, Milord, as per your lordship's direction. 50%, Milord, cash, 50% BG, and the awarded sum is 50 lakhs, Milord. If your lordship kindly takes up page 32, Milord, once. This is the award.
So with interest, it would have gone up.
Yes.
You have to do it with interest.
Milord, Milord, my 34 is pending, Milord.
That's all right.
Milord, I can secure, Milord, the entire this sum, Milord. Milord, if your lordship, Milord, kindly takes up my 34, Milord.
We'll see 34 later. First you...
Milord, kindly takes up page 32 once, Milord.
Page?
32.
That's the award, Milord.
Yes.
Below 31, the ordering portion starts. Below 32E. On account of refund claim by the respondent.
Where are you reading, sir?
Milord, page 31, Milord, the order starts, Milord. Ordering portion starts.
The operative portion of the award.
Oh.
Award.
No, page 31 is some authorization.
But they have handed over this document to me.
Page 31 is the award copy, internal page.
Internal page 31.
Yes.
Yes.
But the award starts over here. Milord, kindly takes up, Milord, page 32.
Yes.
On account of refund claimed by the respondents and admitted by the claimant, a sum of rupees 50 lakhs shall be paid by the claimant to the respondent along with an interest at the agreed rate of 12.5% per annum from so and so date. Till full realization thereof.
Yes.
Milord, I'm just praying, Milord, let us, Milord, this amount, Milord, he is ready to secure, Milord. Milord, this 50 lakhs, Milord.
50 lakhs with interest. Up to date interest you have to do.
Milord, interest is there, Milord.
Up to date interest. There's no question of no interest.
Milord, kindly, then Milord, kindly let me take instruction. Milord, kindly grant us 3 to 4 days time, Milord.
For instruction.
Milords, already 1 year has been passed, Milords.
He's just asking for 2 days for instruction.
Oh, yes, I'm so sorry then. 2 days is no problem.
Next Monday, Milord, we shall, Milord.
All right, Monday, not today, Monday. Let him take instruction, he'll come
yes,
back.
Milords. Yes, Milords. Grateful, Milords.
All right. Other matters after lunch. हाँ हाँ वो तो सिर्फ डेट ही लिया है ना नहीं अलग अलग करो हाँ अलग अपीयरेंस है
The second half.
monthly list নেবে কমার্শিয়াল সাইডে মান্থলি লিস্ট কলো না কেন কি আজকে লেখা আছে না ফ্রম 2 PM পার্ট ম্যাটার ডিটেল কজ লিস্টে একবার কজ লিস্ট দেখুন একদম লাস্টে অরিজিনাল সাইডে
সেটা কি করে বলবো
ওটা একটা ধরবে তারপরে যদি সময় হয়
আপনি জাজমেন্টটা হোক এটা সাড়ে সময় থাকবে যদি নন কমার্শিয়ালে চলে যায় তাহলে অনেক ছোট যদি হয় না হয় তাহলে কমার্শিয়াল ধরে
কমার্শিয়াল মান্থলি 25 টু
আপনি জিপিএম এর নন কমার্শিয়াল আছে
দেখতে
আয়ুর্বেদিক তো চার্জেস কি আছে আপনাদের আপনাদের মোটামুটি 5টার দিকে যদি যাই ঠিক আছে মেল টু মেল হয় সেক্টর 1 আপনাদের না সেক্টর 2 নট এটা আপনার চার্জেসটা একটু ডিসকাউন্ট করে দিলে ভালো
তো তিনটে জায়গায় সেপারেট অর্ডার করে দাও বুঝলে
কত আসবে আফটার ডিসকাউন্ট
12 করে 15 করে দিও না
ঠিক আছে তাই করে দেবেন থ্যাংক ইউ তাহলে আমি 5টার দিকে যাচ্ছি আমাকে কাইন্ডলি একটু এই নাম্বারে লোকেশনটা পাঠিয়ে দেবেন কারেন্ট লোকেশন হ্যালো হুম তোদের ওই থেরাপির জন্য ইয়ে করেছিলাম কন্ট্যাক্ট করেছিলাম কতক্ষণের সেশন হয় রিল্যাক্সেশন মানে as such কোনো হুম 1 আওয়ারের যে নেই চার্জেস কি আছে 1 আওয়ারের মেল টু মেল হয় না মেল টু মেল ঠিক আছে ওকে একটু আমার লোকেশনটা পাঠিয়ে দিন চেষ্টা করছি জানিয়ে দেবো হুম
ফোনে সব ফোন করলে মেসেজ করলে মনে থাকে কত কিছু করছে প্রথম দিকে ফোন ধরতিস না বাজে কথা বলি বাজে বকিস না রাতে ফোন তুই ফোন করবি একটার সময় ঠিক আছে একটা বুঝলি যখন তুই দিন তোরা তো প্রথমে পড়াচ্ছি তখন আমার কথা মনে হয় হ্যাঁ আমার শরীরটা ঠিক হয়ে গেছে কি হয়েছে আমি ঠিক হয়ে গেছে ঠিক হয়ে যাচ্ছে আমি কিন্তু আমি ঠিক হয়ে গেছি আমার একমাত্র ইম্পর্টেন্স আওয়ারটা হ্যাঁ ভাই ভালো না ভাই দশ পনেরোটা করতে পার কোনো না চলতে করতে থাকে আমি বেঙ্গালুরু দেখলাম তারপর তবে হ্যাঁ মানে লাল সাদা না খেয়েছি আমি তোরা বাইরে থেকে দেখতে পাই
দাদা বলো
দাদাকে চিনিস না এমনি দিচ্ছে না ভাই খাওয়া দাওয়া পরে গিয়ে বলি ট্রাস্টেড মাছ ফটা ফটা দিতে আদা মানে ছেড়ে দিই আমাকে নিতে চাই না না আচ্ছা দিব না আমি একবারই ভাই
তাহলে চলে গেল বন্ধটাও বন্ধটা করলো খালি
कबाब बना रहे बट नहीं कबाब
গেলাম থেকে খাবার বাড়িটা খালি হোক সবাইকে ডেকে একটা গ্র্যান্ড পার্টি আচ্ছা 19 কালকে পুরো বুক করছি অন্য পার্টি কত দিকে ওদিকে যাই দাও
every second
হ্যাঁ আমি একটা ফ্রি টিকিট পেয়েছি ভাবছি যে আরো টিকিট চলে যাবো সবাই আকসার খানের সঙ্গে দিচ্ছে আমিও তাই দেখতে পাই চলে কি হবে কত নম্বর
কথা বলছি না আমরা ভাই শুধু এক একটা জায়গায় আমি আর দাদা বলতে কল খেয়ে যাচ্ছে আমি আর দাদা ঠিক ছিল
ভালো করে শুনেছি আমাদের যেতে হবে
এখন ধুতি পরে আসবে পরের মতো
भैया मेरा टेंशन मारा जो बार बार फोन করছে বাবার আগে ফোন করেছিল হ্যাঁ বলে যা কথা আপনি অ্যাডভার্টাইজমেন্ট বলছি তারপরে কেটে দিয়েছি বাবা ফোন করে যাবে বললাম তো বাবা তার আগে বাবাকে বলবে বাবা বাইকটা যাওয়ার জন্য ওইটা করানো যেত বাইক কি করে আমি বললাম তোর আমার কাজটা করতে আমার কাজটা বলে মনে হয় না কথাটা নিয়ে
চায় বেশি কিন্তু যা দেবে তাই তাতে তোমার ফেলার করবে তবে খানা দেখলাম সব খানাগুলো সেল নেই যেমন ঝাড়খণ্ডে পাবে খানাটা অত সেল নেই একটা পাবে কেস যদি এরকম বাইরে দিয়ে ভাই বিশাল ব্যাপার ওদের কাছে ভেরি গুড হিসাবের নামে তুমি নিয়ে যাবে শুধু আর হিসাব দিতে হচ্ছে 50 ওইটারই ওর তো কিছু যায় আসে ওর কি এসে এবার আমি চলে যাচ্ছি সবে বিয়ে করেছে আউটসাইড কি করে ভাই বিয়ে আগে 4-5 বছর ফেল করেছে এখন লাভ ম্যারেজ ওর কি তুই গরম করবি তোকে নিয়ে বসে দেয় কথা বলতে চড় মারবি তো ঠিক আছে না রে ভাই আগে প্রভুকে নিবেদন তারপরে আমরা না এটাই আমাদের চার ঘন্টা প্রায় সেকেন্ড পার্ট বাকি আছে আমাদের আমি লাল কার্ড পুষ্পা না পুষ্পা ফেল না রে এটা স্টোরি আছে বাট টাকাতে পুষ্পা এগুলো তো হাই করে দিল ব্যাস আমরা চাই না কোন ফিল্ম ফিল্মে যাচ্ছে ওই একটা ফিল্ম জীবনে একটা করে দিচ্ছে বলে ওটা না দশ বছর আগে না তেরে নামে হয়েছে তেরে নামে লাস্টে পাগলে করে সারাদিন চলছে ভাই ফোন আসছে গাড়ি
না হলে ওকে আমি ট্যাকেল করতে পারছি থেকে যাবে বাচ্চাটা খরচা করে ফেলেছি গায়ে ডেঞ্জার লাইট লাগিয়েছি ভাই লেতা আরে সবাই মিলে একসাথে খাবো এই এটার মধ্যে ঢাল না হাফ ঢাল না শুভমকে তুই চিনতে পারবি না অন্য মানুষ বুঝতেই ভাই কম বুঝেছিস ঢাল না করে নেবো তো এখানে ডলারে কনভার্ট করবো করে ওখানে গিয়ে নেপালি টাকায় কনভার্ট করবো যাবো নিউ গ্লোবাল না কেপিএ তাই তো না তোকে যেতে হবে ওখানকার এটিএম কোনো ফরেক্স মার্কআপ আমি দিয়েছিলাম ফরেক্স মার্কআপ থাইল্যান্ডে গিয়ে একটা সাইট করেছিলাম আইডিএফসি দিয়ে ফরেক্স মার্কআপ ছিল হ্যাঁ ওটাই হলো কথা ফরেক্স মার্কআপ নরমাল কার্ড হলে অনেক টাকা দিয়ে দেবে বুঝতে পারছিস 2400 টাকা মানে তুই 19-20 টাকা কত টাকা কাটবি সমস্যই ভাই এবার যদি বাইরে প্রচুর টাকা কাটবে ভাই টাকা ফরেক্স মার্কআপেই বেরিয়ে যাবে কোথায় 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 নেপাল ট্রিপে কেরম খরচা হচ্ছে পুরো দাদা ফালতু বকবে না ঠিক ঠিক না 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 আমি আর প্রথমে আমি ভেবেছিলাম ছড়িকে একটা দিনই চলে যাবো কিন্তু কালকে ছুটি তুলে নিচ্ছে ছুটি কালকে হবে ভাই গাড়ি নেই ঘুরে আসবি যখন তখন দেখবো মন্দিরে দাঁড়িয়ে আল্লাহ আল্লাহ করছি কি করে মানবো আমরা ওটা ভাই ডিম দিয়ে ঝালমুড়ি মাখা ডিম দিয়ে ঝালমুড়ি মাখা
আমি ওইগুলো আমার ইচ্ছা নেই আমার শুধু ইচ্ছা আছে ওদের ওই তাওয়াতে যে বিরিয়ানিটা বানায় তাওয়া বিরিয়ানি
কোথায় বাংলাদেশ বাংলাদেশ রিসেন্টলি একটা নিউজ সার্ফেস হয়েছিল একটা ব্রিটিশ মেয়ে ওই যে আন্দামান নিকোবর আইল্যান্ডে কি বড় বাপের কোথায় খায় খাওয়ালেন না ওটা মাই গড
জ্যোতি জ্যোতি ভাই বড় ভাবে পোলা খাই ভাই জ্যোতি খেলে যায়
আমি খাও আমরা খেলাম তো ওই পাস্তাটা খেলাম তো তারপর এটা কি খেয়ে যাচ্ছে
বাড়িতে গ্রিল আরে ভাই বললাম তো ভাই চেষ্টা তো করলাম ভাই কম চেষ্টা তো করি ভাই বললাম ড্রাইভার ফাইভার দিয়ে দিচ্ছি ভাই যদি না যায় আমি কি করবো আর কি করার আছে আমার আমি তো নেই ভাই এখন কোনোভাবেই আমি নেই
এই চেনটা কি ছোট করে
হ্যাঁ হ্যাঁ ওটা কেটে দিতে হবে এই মালটা পিছিয়ে দিতে হবে এটাকে পিছনে করে টান 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 টেনে দে। আরে ধরে টান হ্যাঁ এই সাদা মালটা তোর হাতে ঠিকঠাক হয়েছে
হ্যাঁ কাটিয়ে
ধরে পেরেছিস তো সিমেন্ট খুলে বের করে দিয়েছি তুমি তো ভাবি আমার কাটাতে পারবি কি পারবি না
কাটি দেখতে ভালো
গ্রিন কালারটা মাথায়
আমি দেখছিলাম ছেলে এটা মনে হচ্ছে টাউন হলের সামনে থেকে আনি তাই ওই স্মোকি ফ্লেভারটা পাওয়া যায় হ্যাঁ
তারপর সব মাঠে
না ঠিক আছে একটু গেলে সে দাগ 12,000 সাল 12,000
বড় বাপের কোলা বড় বাপের কোলা বিয়েটা কর তুই এরকম একটা বড় বাপের কোলায় খায় করে আসবি
বসে বসে এমন ভাবে উঠে বসলি মালিকদের পরে উঠছে দাম করতে জায়গা দিচ্ছে আস্তে আস্তে জায়গা দিচ্ছে না ভাই উঠতে কি করে বাবাকে নিয়ে আসবি নিজের গাড়ি নিজের গাড়িতে বাবাকে নিয়ে আসবি হ্যাঁ এখানে আমি সেভ করলে বাবা এখানে আমি মনে এবারে সাদাটা নিয়ে
বাইরে বোম মেরে দেবে ভাই, কান পেটি না হয়। এটা কর। তখন আমাকে জিজ্ঞেস করবি না, আমি তোকে জিজ্ঞেস করবো কথা, কি রে হঠাৎ করে ব্যাচেলার ছেড়ে হঠাৎ করে রোহানের পোচ ছেড়ে তুই একা একা যাচ্ছিস এরকম করে।
মানে একটা জিনিস ছেলেদের জীবনে 1 থেকে 30 বছর আচরণ, তারপরে
রোটি রিটার্ন বিয়ে করে লজিকটা বুঝে গেছে ভাই, রানিং বুঝেছে ভাই।
আমার নাম হচ্ছে নতুন ল্যাঙ্গুয়েজ নাম। হ্যাঁ, আমার প্ল্যানের রান্না বান্না হয়নি গো। হ্যাঁ, আমার শুধু আমার 36,000 এর সুইগি এসছে 1 মাসে। ঠিক আছে, ঠিক আছে, রেকর্ড 5 বেলা খেয়েছি, 5 বেলা এরকম 5 বেলা শুধু করে খাবার। কিচেনের দিকে যাই না, ওই জানলা দিয়ে তুললাম, ওই ঘরে বসে খেয়ে প্যাকেটটা বাইরে।
এখন দেখবি মাঝে 36,000 ব্লিঙ্কিট বাস দেখতে আসবে, দেখে নি।
ব্লিঙ্কিটে মানে ভাবে যে ব্লিঙ্কিট আসছে না, কি বলবো, ভুলে যাচ্ছি শুধু একটা জিনিস মনে পড়ছে, আবার ওয়েট করছি 200 টাকা করতে হবে, ডেলিভারিটা ফ্রি হবে। আমার ওখানে জেপ্টো নেই, আমার ইনস্টামার্ট আর ব্লিঙ্কিট।
আমাদের ফেসিলিটিটা আছে ভাই, তোর মধ্যে কম্পিটিশন আছে।
হ্যাঁ, জেপ্টো ইনস্টামার্ট তবে আমাদের জেপ্টোটা চলে না। হ্যাঁ হ্যাঁ, আমি ওটাই ভেবেছি এবারে, আমি ওটাই ভেবেছি যে একদিনে গিয়ে সব কিছু বেশ সব করে নিয়ে আসা।
মাসে একবার তাউসিডি যায়, ফুল মাল করে নি ওইখানে চলেছি, খালি বাজারটাও বিক্রি করছি। না তোর ফেসিলিটি আছে, তোর যে ফেসিলিটিটা আছে তুই সেটা লস করবি কাজে তো লাগা। সেই ফেসিলিটিটা তোর আছে ভাই।
তোরটা তো ফ্রি পুরো। চলে আসে। পেমেন্ট করে কিনা আমি জানি না, এখান থেকে ডেবিট হয়ে টাকাটা মেসেজ আটকে যায়, মেসেজে আটকে যায়, আটকে যায়, এবার আমি ওখানে কিছু বলতে পারছি না। আমি বলতে পারবো না।
ব্যাপারটা তো সেরা ভাই, গল্পটা তো লাভ নেই, ইনসেন্টিভ স্কিম এসআইপি করে দিয়ে যাবে হালকা করে। ওরই প্রাইস নিয়ে তো বিলিং তো অন্য জায়গায়।
না, আজকে আমি এসবিআই থেকে বাজার করতে না না ভালো
কোন এসবিআই?
এই তো কোঅপারেটিভ থেকে কিনে নেবো। আমাকে
ওর ভেতরে জায়গা আছে?
এভরিথিং ইন সস্তা, অনেক সস্তা, অনেক সস্তা।
না রে, সব একই দাম না।
হ্যাঁ, 1000 টাকায় এয়ারপোর্টস প্রো কিনেছি।
ওগুলো তো জালিমাল ব্যাচে বলে, মনে পড়ে যায়। আরে জালিমাল ব্যাচে বলে সেটা
কে বলেছে তোকে? মুখে 2 টাকা ছাড়ে ভাই, দাম বলছি
না দেয় 500 টাকা। কি বলছিস?
ও যেটা বলে দিল যে প্রোডাক্টটা, ওটা হচ্ছে খুব চলছে প্রোডাক্ট। তুমি যখন যদি হট চকলেট ক্যাডবেরি কেনো, যা দাম তাই নেবে, বুঝতে পেরেছো? ওইগুলো দাম দিয়ে সর্ষের তেল, ধূপকাঠি, ডাল চাল যেগুলো রয়েছে, গিফট আইটেম যেগুলো রয়েছে, প্রিন্ট থাকবে, বিলিং এ যাবে, আমরা স্টার্ট করে দেবো।
অয়েল ড্রপ
তুমি একটা এয়ারপোর্ট
কালকে বাবু বড় লোকের কি বলবি, কি বড় লোকের বেটা খায় নাকি দেখিয়েছিল, বড় লোকের বেটা খায় ঘুরাতে দেখা হলো। তুমি দেখছো ফোনটা এই পাশে রাত্রি মনে হলো ভাই মালটা ঠিক করে ও মনে হলো এটা যাওয়ার সময় আমি একবার বলে দেবো আস্তে মাসতে কাটতে মারতে দেখি যাই ঠিক মালটা তাহলে ফোন নেই, ষোলোটা ওখানে রেখে দিয়ে চলে এসছে ওই একটু টেনশন আছে, আমি টেনশন পাচ্ছি ওমন খাম পড়তে পারছি ফোন নেই নিচে পার্কিং লটে এসে গাড়িটা পুরো 5 লাখ গাড়িটা খুঁজে পাই বেরিয়ে যাবে
গাড়িতে বসে যখন দেখলাম কার্পেটে কানেক্ট করছে তখন আমার
ছুটে গিয়ে বাবুকে আমি দৌড়াচ্ছি ভাই লিফট থেকে বেরিয়ে পাই করে দৌড়াচ্ছি ভাই ছুটি ছুটি ঢুকে গেলাম ভাই নেক্সট চালু হয়ে যাচ্ছে ভাই এটা দেখছি নেই, আমি ভাই দেখতে গিয়ে পড়ে পড়ে যাচ্ছিলাম ভাই এত দৌড়েছি দেখি নেই ক্যামেরা দেখবো হ্যাঁ ভাই তারপর যদি চলে গেল ভাই ক্যামেরায় তার মুখটা দেখতে হবে ভাই তারপরে দেখি মানে ওই কখন আমাদের জিজ্ঞেস করলো ওই সিকিউরিটি আমরা বুঝিয়ে দিই না সিকিউরিটি গার্ড তারপর ছবি তুললো
হ্যাঁ ভাই আমরা মোর একটা গেলে আর একটা রাত বিলম্ব আছে।
और दीवार की है ना ओनली वन थिंग से सपोज আমাদেরকে দেখিয়ে দেয় তাহলে তো চলেই গেল ধরে নিচ্ছি
হ্যাঁ
মেন ব্যাটারটা করতে বলবে
স্যার
নেশা নেশা নেশা
তো
point. Oh, I don't know. I'll say it. So no.
So this is Krishna Sir Junior.
Yes, yes. The last occasion, he came in the arbitration. He came in at the arbitration.
Sir, हाँ सर सुबह फर्स्ट हाफ में तो नहीं अपलोड 37 अगर
Your law firm,
so NUJS.
Calcutta.
Yes. So after that I clocked at the station. Then I went to UP.
My sister also from yes, Calcutta.
Your sister?
My sister from
हाँ.
the first batch.
Okay, so Avinash
এটা
said
কথা কাগজগুলো কথা
she must be 43 now. 44. I am from
ওই also from yes, Bangalore.
Okay.
And I লোকজন বলবে ভাই আছে বলে দাদা আছে রে তোমার লাগতে পারে 300 কি নাও লাগতে পারে তারপর তো অরিন্দম ব্যানার্জি আছে
The main factor, the one for अगर हरा तो
না তো আপনি
Such was the main matter.
हाँ बोलो
ये चीज
हाँ हाँ कि ওটা কনফারেন্সটা তোমরা করে নাও ও তন্ময় করে দেবে আজকে করো না ম্যানেজ করো কালকে
I just informed
আমারটা কোথায় বললাম কোথায় বললাম কোথায় রেখে সাউন্ড কোথায় নোটস এন্ড এলওডি না না তাহলে এইটা হ্যাঁ ইমিটেশন একটা আছে ইমিটেশন একটা আছে ইমিটেশন একটা আছে
नहीं हाँ बात हो गई हाँ हाँ she said next week
call the matter sorry. I'm serious. हाँ तो कहना उस Yeah. He apparently that's why he kept it. That's why he তুমি নেই তো তুমি না থাকলে নাককে ধরো ক্যাচ শুভম ক্যাচ শুভম ক্যাচ শুভম আমি 45 minutes তো বলবো I will give you the other after that submissions can be for at least an hour 45 minutes for sure doing the judge আমার very fast you all I cannot say for sure it will not be safe for me to do a small shape and come back তো দুনিয়াকে বসিয়ে না তারপর কি ক্লোজ হয়ে গেলে তো না না ক্লোজ করতে দেবো বল তো জুনিয়র করতে আচ্ছা তাহলে ওকে বসিয়ে যা তোর কতক্ষণ লাগবে আমার হতে মানে আপনার একটা জাস্ট জাস্ট মুভ টু মানে 20 minutes 20 minutes এইটা অরিন্দম আমি বলতে পারবো ওখানে 10 মিনিট হ্যাঁ তাহলে চাপ উচিত হবে না বলা আমার ফেয়ার হবে এইগুলো ওইটা হবে না, ওটা তো আপনি আগে বলে দাও কম ওটা তো time লাগে। না না এই ওটা দিয়ে এই অঙ্কটা শেষ করবে ও বলতে পারতা ওই একটা পার্ট বলতে
আপনি পালাবে কেন ভাই? পালালে হয়
हाँ वो तो सही है उसका फोन नंबर दे दो অসাধারণ তো মানে হচ্ছে
মানে কি বলবো মানে এরকম
হচ্ছে ওজন মানে হচ্ছে সাব অ্যাটমিক পার্টিকেলস কোনটা প্রেডিক্টেবল ক্যারেক্টার যেখানে পাচ্ছে যার সঙ্গে কোলাইড করছে এনার্জি ট্রান্সফার করে
আগে বলবে আরে আরে
এটা ওর ষষ্ঠ বলতে না না ঠিক আছে পাবলিক তো বোঝেনি
একটাই খেলা অন্য
রোহিত তো ডেফিনেটলি এখন রোহিত যে নিশ্চিত হয়ে রোগা হয়ে আমার 4-6 মাস অন্তর 6 মারছে মানে ঠিক করে 6 মারছে মানে ও হয়ে গেছে প্রবলেম মানে বাড়ি গিয়ে গাড়ি ধরে মানে অসুবিধা হবে
আবার মোমেন্টটা কি
মান থাকলে টেস্ট ম্যাচে আমরা এরকম অবস্থা হবে
বা 10 জন
সুপারি মানে যখন যাকে তেলাতে হবে তাকে তেলিয়ে লাভ তুমি ওই জন্য ধোনিকে সহ্য করতে পারতো না এদিকে বলতো ধোনির চেয়ে ভালো প্লেয়ার তারপরে বলতে শুরু করলো ধোনি একটা ওয়ার্ল্ড কাপ জিতে আমি 6 উইকেট জিতিয়েছি এটা ফ্যাক্ট 6 উইকেট আজকে করে দিয়ে তারপরে বললো ধোনি
বাদ দাও
ধোনি ম্যাজিক মানে কোনো খেলেই এভরি ডে
ফাইনাল দিয়ে বাদ দাও কথা কিন্তু লিডার কনফিউশন প্রত্যেক ম্যাচে তার
সচিন সচিন করেছে সচিন ইউপি
মানে ইনফ্যাক্ট ম্যান অফ দ্য টুর্নামেন্ট ক্যান্সার পেশেন্ট
সেই অবস্থায় উনি তো আর ক্রেডিটটা কারেনি তারপরে 6 মেরে ব্যাটটা এরকম ঘুরিয়েছে এবং দ্যাট হ্যাজ বিকাম দ্য মানে মানে ফিচার পোস্টার এভরিওয়্যার ওর কি দোষ আছে 6 মারতে জানে ওয়ান প্লাস এখানে একটা 6 মেরে একটা ঘোরালো সোয়াগটা কিছু তাই তো ইস্ট বেঙ্গল ওয়েস্ট বেঙ্গলে মার্চ হয়ে বেঙ্গল টিম হবে ওটা কিন্তু সাংঘাতিক ভালো মানে ডেডিকেটেড টিম
বড়
হোয়াইট বল বলতে মেনলি 50 বল ও টি20 তে তো খেলতো কেকেআর হয়ে খেলতে কি পারতো ভালো
দিতেও
স্যারকে জিজ্ঞাসা ম্যাচটা কবে যাবে
এই স্যার যেদিন চাইবে
22 তারিখ হ্যালো হ্যাঁ
22 তারিখ নয় 22 তারিখ
আমার তো 22 এই করেছে বসে গেছে এসে গেছে ব্যাস বসলে তুমি আমাকে একটা মেরো দাদা আর পুজোটা করে দিও পুজোটা করে দিও পুজোটা ডোন্ট ওয়েট ফর মি সেইটা করো এবার ইন দ্য মিন টাইম এই স্টেজ জন্য একবার একটা আজকে আমরা স্টেজ চাইছি আইডেন্টিটি নাহলে খুব আর্জেন্সি আছে বলে এই একটা রিফিউজাল খেয়ে দেবো তাহলে হ্যাঁ ওই রিফিউজালটা খেয়ে না না OnePlus থেকে এবারে একটা খুব ভালো করে ঠিক করছে ভীষণ ভালো করে ক্যামেরাটা ওদের বিগ পয়েন্ট আছে হ্যাসেল প্ল্যান
বলো না 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 যাইনি আমি এখানে আছি যাই যাওয়ার কথা ছিল যাই
কেন অর্ধদম বলছে ভালো না ফর্ম ফ্যাক্টর খুব ভালো
বলে মারতে পারছি আমাকে এইসব আপনার কি
লেটেস্ট কি দেখলি না আমি কাল দেখছিলাম
এটা যাবো আজকে যাবো চা হোক না কেন আজ যদি রাত্রে করে তুমি রাত্রে
হয়ে গেছে
মানে ওয়ান অফ দোজ সেই
ভালো কেন তো মোটা লোকের ছবি এরকম করে ক্লোজ আপে উল্টো পাল্টা ছবি তুলতে বুঝবো
দেখো তোমাকে
আমাকে তো
আমাকে
এটা খাবারটা কোথায় ভাই খাবারটা লাগা খাবারটা হ্যাং করছি একটা ফলোড করছি সেটা আমার স্মৃতি করতে পারবে একবার আইপ্যাডটাকে একবার শাটডাউন স্টার্ট করে আর দেখতে অনেকটা কাজ বন্ধ করে
ছিল এককালে বলো আমার আজি তো ফর্সা ছিল না আজিদের হালকা একটা না আজিটা বুঝছি ভালো আমি যাবো যেতে পারি
দুরান্তারে খান্নার
দারুণ
না
চার টুকরো হয়ে গেল এগুলো শুনলে গা করা আমরা বাচ্চাদের যেমন লোক আমাদের হিসাবে যারা পিপি করলে ভালো লাগে সেটা কার্তিক আর্জুন কি যে কুমোরটা বোধহয় একটা ক্যামেরার চেক
পড়ে গেল
আর পাঁচ যখন খবরটা ব্রেক হলো যে ওর বোনকে উঠিয়ে নিয়ে গেছে চোখ পুরো লাল চোখটা লাল বলে মানে নিজে নিজেকে বলছে বলে একটা কান্না হাসি দিলে একটা তারপর বলে এই ম্যাপ আনো মুসলিম ম্যাপ ফেললো ভাই আসে ঘুষে তারপরে সোট দিয়ে দেবো
ওটাই কিন্তু আইকনিক মুভি
ও
এই যে যত এইসব কেজিএফ পেজিএফ হয় কেজিএফ পেজিএফ হয়েছে সব কিন্তু ইনফ্লুয়েন্স তুই দেখবি ক্যামেরা মুভমেন্ট তো একরকম আর তুই একটা দেখবি ওই কাইন্ড অফ কি বলবো নয়ার এফেক্ট দেয় সেপিয়া নয়ার টাইপের এফেক্ট
হ্যাঁ ওই তোমার একটু হালকা সেপিয়া
এখন আমরা অন্য জায়গায় চলে গেছি মানে
তারপরে মারছে তারপরে মারলো কি
আমার 40 লাগা উচিত নীল বিদ্যা যাচ্ছে
দল থেকে
टोपी संभालो दिक्कत रहो हवा तेज কবিতা বন্ধ তো কারিয়ার ফারিয়ার এইগুলো তো শিখলি কেন এখন অব্দি মানে কাজ
কালকিটা হলো
হ্যাঁ
কালকিতে আসার পর সিটটাই চেঞ্জ হয়ে গেল
আমি একটা ছিল আমি আম দেখেছো
আমি একটা তিন
আমার একটা ছিল বাস ড্রাইভার
এক্স্যাক্টলি ব্রো
দাদা দাদা একটা ফ্যান চলো তো একটা ফ্যান অ্যাটলিস্ট একটা এতগুলো জিনিস পুরো না গরম দম বন্ধ লাগছে
भाई साहब थोड़ा तो बोलो भाई साहब वो है तमीज के बाद ये लड़की ये तो भाग गई वो तमीज के बाद ऐसा होने से तो कोई भी उसको उठा के ले जाएगा
একটু এদিকে পেছনে কোনো একটা চালিয়ে দিতে বলো সাফোকেটিং লাগছে
সব দেখে আমরা মানে চেয়ার ফেয়ার ভেঙে দিই
আমি পাশে এলো তো তো
এটা বলতে হবে আমি তাছাড়া লোকে আছে ওই তো বলছে চিফ জাস্টিস অফ ইন্ডিয়া পড়ে নায়কের
দেখে দিন দেখি
Remind me that she was asking for adjournment. Did I say that since I found the judgment garbage? I hope I did. That would have been cheap. I would have said it as a joke and then not realizing that it's a thing. I know.
সেটাও খেলো আপনি আর রোমান্টিক কি বলতে মানতে আপনি দেন না লাইফে কি পেয়েছি আর মাই 1 lakh for 1 million air miles আজকে আমার 1 million air miles এটা অনেক
ওই বলছিলাম আমার জন্য কসমেটিক চিঠি দেবে নিয়ে ওই যে মামলাটা জজ সাহেব জিজ্ঞেস করলাম Yeah, you know that, yeah? Yesterday it started. So then today I'll start that. What's that card? डायरी कि नहीं खाती बाकी हमें चाहिए डायरी डायरी
देखो तुम्हारा वरना तुम्हारा एक्सेप्ट जो कौन ये बोले देखो चापली
judgment item number 1
one
In view of the foregoing discussion and for the reasons recorded herein above, this court arrives at the following conclusion. The jurisdiction court competent to entertain and determine the present proceeding within the meaning of Section 21E of the Arbitration Conciliation Act is this court. Under Section 42 of the Act applies with full rigor to appeals preferred under Section 37(2). Such appeals being in continuation of the proceeding arising out of application made under Part 1 of the Act, and consequently the present appeal is maintainable before this court. The preliminary objection as to jurisdiction is hereby rejected. Let the matter be listed for further consideration after 2 weeks.
Deeply obliged, Your Lordship.
इसको sign कर देना. Just कर देंगे ना after 2 weeks. After 2 weeks for the hearing. Huh?
Section 5. चलो वो दिखा वो ठीक है, एक बार चेम्बर भेज देना आपको देख ऐड कर दो फॉर द हाँ डिस्पोज जी वन। ऐसे ये मेन अपील में जाएगा, जीवन रहने तो मेन अपील के साथ करते हैं। हाँ वो हाँ इसको ये फाइल अभी भिजवा देना, मैं उसमें करेक्शन। हाँ सर एक ही है ना।
Item number 553.
Your Lordship, I have for the judgment date number 2.
Finance versus Gaji Egg Center.
I appear for the award holder, my lord.
You are appearing for him.
Judgment date number 2.
पैसे क्यों नहीं दे रहे हैं?
এই ব্যবসায় লস হয়েছে আর পার্কে পয়সা পড়ে আছে অনেক, সেই জন্য দিতে পারছি না।
बोलो देना पड़ेगा। You have to make the payment. Tell him.
आपको টাকা ফেরত দিতে হবে।
হ্যাঁ দেবো, সময় লাগবে একটু।
রেকর্ডে দো।
যেটা বলছি আমার সাথে সাথে বলুন। বলুন আমি শপথপূর্বক বলছি।
আমি বলছি
আমি শপথপূর্বক বলছি।
আমি শপথ করে বলছি
এই মামলায় আমি
যা বলবো সত্য বলবো।
সত্য বই মিথ্যা বলবো না।
সত্য বই মিথ্যা বলিব না।
কোনো কিছু গোপন করব না।
কোনো কিছু গোপন করিব না।
আপনার নাম?
হায়দার আলী গাজী।
আপনার বাবার নাম?
সেকেন্দার গাজী। SEKEN
গাজী। আপনার বয়স কত?
আমার বয়স ওই 32 প্লাস।
আপনি কি করেন?
আমি ডিমের পাইকারি করতাম, ব্যবসা করতাম। হ্যাঁ।
আপনার বাড়ির ঠিকানা বলুন।
হাসিমপুর।
পুরো ঠিকানাটা বলুন।
হাসিমপুর বহড়ু, সাউথ 24 পরগনা, জয়নগর।
কোর্ট আপনাকে যখন ডাকবে আপনি কোর্টে উপস্থিত থাকবেন?
হ্যাঁ আসবো।
আপনি জানেন আপনি যদি না আসেন কি হবে?
হ্যাঁ।
আপনার জেল পর্যন্ত হতে পারে। আপনি
আমি
আপনার
আসবো।
সম্পত্তির এফিডেভিট কোর্টে দাখিল করবেন?
নিশ্চয়ই।
Award letter number 2 has been produced.
With the leave of the
in terms of the warrant dated so and so. Warrant issued by this
with the leave of the court, otherwise go to the
dated
department.
17 September 2025. Oath has been administered. You'll file it in. You're filing it.
No, Your Lordship, today I will not.
All right.
By when?
The award letter number 2 undertakes to file his affidavit of asset within a period of 2 weeks, and he further undertakes to make himself available before the court as and when required. List after when
Leave to file.
Thursday.
Leave to file the wakalatnama.
After 3 weeks after vacation. After vacation is for leave.
Request for leave to file the apology.
ये वकालतनामा यहाँ या
डिपार्टमेंट की much
No. Appellate side matter. Appellate side matter. Sorry. कौन हाँ वही हाँ
item number 1 partner matters. What I have done for the Lordship's kind consideration, I have just prepared a skeleton note regarding the reply.
Okay.
It's
Can I-
skeleton. Because my time is so valuable now. So, may I just take your Lordship through the notes and then I will try to expand. My Lord, I am not making the submission that the enactment has been made, that the state legislature does not have any competence to enact laws. Law is settled. The state legislature can also enact laws with retrospective effect if the situation or the occasion so arises. They have to meet the tests. The state legislature can also make declaratory or statutory or clarificatory provisions. But in this case, what has happened, my lord, the Honorable Division Bench had specifically fixed a time limit. Time limit of 3 years, so far as section 179 2D is concerned. And that time limit is sought to be, my lord, rewritten by this legislative enactment to 6 years. This is 179 2D I. I will come to II later. In my most respectful submission, that is not permissible. And I will cite authority for that. Then, my lord, this judgment rendered by the division bench of this court was not interfered by the Honorable Supreme Court, as your Lordship has noted that. Thereafter, review petition filed, review dismissed, SLP filed, SLP dismissed. And, my lord, the Amendment Act was enacted during pendency of the SLP before the Honorable Supreme Court, challenging the order dismissing review petitions. It is our specific case that the state legislature has amended section 179 2D to, my lord, to give overriding power to the KMC for making periodic assessment. My lord, the statement of object and reasons appended to the bill, the amendment bill, says so explicitly. Next submission would be section 179 2D II seeks to abrogate the judgment rendered by the division bench of this honorable court with retrospective effect. Then a submission was made by Mr. Kaur appearing for the KMC. Reference was made to section 180. Well, kindly take section 180 for once. Kindly take the KMC Act, section 180 for once.
Yes.
Kindly take section 180 subsection 2.
Yes.
The municipal commissioner may cause any revision to be made in the annual valuation of any land or building in the following cases. The specific instances have been laid down under subsection 2 of section 180. Now, what proviso says is that subsection 2 of section 180, which has been introduced by the Amendment Act of 2022, it says that provided such revision of annual valuation of any land or building shall ordinarily be made within 6 years from the date of occurrence of any of the above circumstances, but such period shall not apply where the owner or person liable to pay property tax fails to submit return under section 182 or suppresses the occurrence of any of such circumstances. Any of such circumstances would obviously mean the circumstances laid down under subsection 2. The whole purpose of the proviso is that it gives an extended period of limitation. It vests the authority with the power that you can revisit any periodic assessment if the assessee has either not filed return or suppressed any of the circumstances laid down in subsection 2 of section 180. The Lordship has dealt with several fiscal statutes. These kind of provisions exist either in section 74 of the present GST Act, section 73 of the Finance Act, Chapter 5 of Finance Act 1994, Section 11A of the Central Excise Act, now Section 147 of the Income Tax Act, which gives an additional period wherever any fraud is detected. Malad, the expression here is used is suppression. In those statutory provisions, the expressions which are generally used, fraud, collusion, willful misstatement with the intention to contravene provisions of the chapter, malad, or the act. So this is one
similar perimeteria, similar provision you will also find in the municipal laws also.
municipal laws also. In the Indian Stamp Act also, malad. Absolutely. I bow down to your lordship. Now, malad, kindly now take along with this, would your lordship kindly take the bill for once? I handed up the copy of the bill. জজ সাহেবকে এটা দেওয়া হয়েছিল
he would have
একটা অ্যামেন্ডমেন্ট বিল আছে হ্যাঁ আমি বার করে অ্যাক্সিডেন্টলি হ্যাঁ এই kindly take my lord the statement of object and reasons appended to the bill.
Yes.
Now, my lord, kindly take II is essentially 179(2)(d). It is considered necessary and expedient to amend the Kolkata Municipal Corporation Act 1980. Kindly take II giving overriding power for making periodic assessment of any land or building within stipulated period after expiration of the earlier period of assessment and giving effect of such periodic assessment retrospectively when it has not been revised after immediate expiration of the earlier period of assessment and for validation of such periodic assessment which has already been made or revised after stipulated period, including realization of property tax on it. Now, but III, it pertains to, my lord, section, the insertion of proviso to section 180 subsection 2. Fixing period of ordinary division of assessment of any land or building as well as non-application of the said building, the present period, on failure of submission of return or suppression of fact by the owner or person liable to pay tax. So, my lord, essentially, III is merely an amendment. II, that is 179(2)(d), is amendment cum validation. So, III, that is the proviso inserted under subsection 2 of section 180 would obviously have prospective effect. It cannot have retrospective effect. And II, that is matter 179(2)(d), they are claiming it to be a validation provision. So they intend to give it a retrospective effect. That is the sum and substance. Now, my lord, now kindly take, my lord, the next submission. My lord, reference was made to section 29(2) of the Limitation Act, your lordship may recollect. My lord, judgment was cited by, my lord, Mr. Kaur, namely, my lord, LS Synthetic, and also, my lord, section 17 of the Limitation Act was also pressed into service, and judgment was cited by Mr. Kaur, namely, my lord, Saranpal Kaur Anand, 22(8) SCC 401. One is, my lord, 2004 11 SCC 456, paragraphs 38, 39 and 39 and 31. And, my lord, Saranpal Kaur Anand, that's a case of section 17 of the Limitation Act. My lord, my respectful submission of you for your lordship is that, but if your lordship kindly takes the Limitation Act, your lordship has read it so many times, but for the sake of completeness, may I take your lordship through the Limitation Act for once?
Do you have a copy?
Yes, I have a copy. I have a copy. Definitely I have a copy.
मिल गया. Yes. Section
29(2), because these judgment rendered by the Honorable Supreme Court in LS Synthetic, well, it is regarding application of section 29(2) of the Limitation Act.
Yes. Yes.
Your lordship will kindly take 29 subsection 2.
Yes.
Where any special or local law prescribes for any suit, appeal or application a period of limitation different from the said period prescribed by the schedule, the provisions of section 3 shall apply as if such period where the period prescribed by the schedule and for the purpose of determining any period of limitation prescribed for any suit, appeal or application by any or special or local law, the provisions contained in section 4 to 24 shall apply only insofar as to the extent to which they are not expressly excluded by such special or local law. Well, the whole idea is that if section 29(2) is placed into service, well, they relied on a judgment that the period of limitation can be extended subject to certain circumstances. Well, your lordship will find section 29(2) refers to section 3. Kindly take section 3 for once.
Yes.
If your lordship kindly take section 3, your lordship will find it refers to subject to the provisions are contained in section 4 to 24, that is part 2 and part 3 of the Limitation Act. Inclusive, every suit instituted, appeal preferred and application made after the prescribed period shall be dismissed, although the limitation has not been set up as a defense. Well, my respectful submission before lordship, the Limitation Act 1963, part 2 and part 3, or even 29(2), which has reference to 3, section 3, because the period gets substituted. For example, if the period of appeal under the general law, common law is 1 month. If the period of appeal in a special statute is 4 months, then 4 months would be treated as a period of appeal for the purpose of section 3 of the Limitation Act. Then in that event, my lord, it would be suit, appeal, it will be suit, appeal preferred and application made. It cannot apply to assessment proceedings. It can never apply to assessment proceedings. Interestingly enough, my lord, Mr. Kaur also relied on a judgment rendered by the Honorable Supreme Court in HON'BLE. Lordship knows what happened in HON'BLE. All these statutory appeals, section 35G, section 260A appeals, and section 130 appeals before the Supreme Court, one under the Central Excise Act, the other is Income Tax Act, the next one is Customs Act. All those appeals stood abated since, my lord, the appeals were not preferred within the prescribed period provided for in the relevant provisions. And at that stage, there was no provision for condonation of delay. So they applied section 29(2), and why section 29(2) is not applicable? In that, after the judgment was rendered by the Honorable Supreme Court, judgment was rendered in sometime in 2009. Your lordship will find all the Union Parliament came to the rescue of, my lord, these revenue authorities and inserted a provision for condonation of delay. For example, my lord, subsection 2A in section 260 of the Income Tax Act, and also some other provisions in the different provisions, namely 35G and 130. Well, it relates to appeal. Similarly, my lord, what happens in the KMC Act, if your lordship kindly takes the KMC Act for once, kindly take, my lord, for once, section 189 of the KMC Act, where Limitation Act applies. Kindly take section 189.
Yes.
My lord has got that. This is appeal to the, my lord, the appellate tribunal. Kindly take subsection 7. My lord has got that. The provisions of part 2, my lord, obviously section 4 to 24 and part 3 of the Limitation Act 1963 relating to appeal shall apply to every appeal preferred under this section. This is not assessment. Assessment proceedings are essentially, my lord, proceedings which are initiated for the purpose of arriving at the liability of an assessee to make payment of property tax or any payment of any tax, any duty under the relevant fiscal statute. To that, my lord, Limitation Act does not apply because it is neither suit nor appeal nor application. So these judgments, my lord, my respectful submission is 2004 11 SCC 456 relied on by Mr. Kaur, 2022 8 SCC 401 are not at all applicable to the facts of the case and not at all applicable for the purpose of interpreting provisions, namely section 179 2D of the KMC Act as amended by the Amendment and Validation Act of 2022. These are Even I'm grateful to Mr. Kaur for referring to Hongo. That gave me the cue. That gave me the cue. Now, my lord, another submission, very interesting submission has been made by Mr. Kaur. Mr. Kaur has referred to A.C. Sharma to say that the statement of, for the purpose of interpretation of statute, statement of object and reasons are not is not relevant. Interestingly, Mr. Kaur also relied on a judgment rendered by the Constitution Bench in Vatika Township, that is 2015 1 SCC page 1. Kindly take my lord Vatika for once. What forms the basis of the judgment is very important. My lord, the Supreme Court was at the occasion to consider the retrospectivity. I'm sorry, madam. Well, may I? Your Lordship has not got the copy. I'm sorry, madam. I'm so sorry. ভাটিকাটা জয়দীপ কর সাহেব দিয়েছে। হ্যাঁ 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 Lordship will find what was Vatika was all about. Madam has got Vatika. It is there. In the must be there in the compilation. Well, kindly take Vatika. This is so important, so relevant.
Yes.
Vatika, Your Lordship will find it was the retroactivity or the of section 113 of the Income Tax Act was being considered, that levy of surcharge in cases of block assessment. What form the basis of the judgment, Your Lordship will find from paragraph 42.1. Kindly take paragraph 42.1.
Yes.
May I read paragraph 42.1 and 243? Notes on clauses appended to the Finance Bill 2002, while proposing insertion of proviso, categorically states that this amendment will take effect from 1/6/2002. These become epigraphic words when seen in contradistinction to other amendments, specifically stating those to be clarificatory or retrospective, depicting clear intention of the legislature. It can be seen from the same notes that a few other amendments in the Income Tax Act were made by the same Finance Act, specifically making those amendments retrospective. Then the examples are given. Kindly come to the last sentence of paragraph 42.1. The notes on clauses show that the legislature is fully aware of three concepts: prospective amendment with effect from a fixed date, retrospective amendment with effect from a fixed anterior date, clarificatory amendments which are retrospective in nature. Thus, it was the conscious decision of the legislature, even when the legislature knew the implication thereof and took note of the reasons which led to the insertion of the proviso, that the amendment is to operate prospectively. Learned counsel appearing for the assessees sagaciously contrasted the aforesaid stipulation while effecting amendment in section 113 of the Act with various other provisions not only in the same Finance Act but Finance Acts pertaining to other years, whether the legislature specifically provided that such amendment to be either retrospective or clarificatory. In so far as amendment to section 113 is concerned, there is no such language used, and on the contrary, specific stipulation is added, making the provision effective from 1/6/2002. But it doesn't stop there. It also relies on the explanatory memorandum at paragraph 43, which is in the nature of contemporaneous expositio. So, my lord, notes on clauses appended to the Finance Bill is, my lord, a relevant material. So, also, my lord, the statement of object and reasons appended to the any bill, my lord. This is not a Finance Bill, obviously. It's an Amendment Act. So, my lord, this is, my lord, the judgment rendered by the Supreme Court in Vatika makes it abundantly clear that any Finance Bill, notes on clauses or statement of object and reasons, even the explanatory memorandum, is a relevant material for the purpose of ascertaining the true intent of the legislature. A. Now, my lord, kindly come to Lohia machines, the next judgment. This is 85 to SCC 197. Now, what was the issue in Lohia machine? My lord, relevant paragraphs would be 7, 8, 82, 83. This is 85 to SCC 197.
Yes. Paragraph
7, 8, 82, 83. I will not take your lordship to the paragraphs. Those are lengthy paragraphs, but may I just give your lordship the gist, subject to your lordship's kind consideration.
Yes.
Well, in this case, the Supreme Court held that Rule 19 capital A, which excluded the borrowed capital for the purpose of computation of capital employed in an industrial undertaking under Section 80J, well, those are the deductions available to the new industrial undertakings, to be invalid, and the subsequent incorporation of the provision contained in Rule 19A in Section 80J with retrospective effect was also held to be invalid to the extent that it could only be made applicable prospectively. This judgment has no bearing to in the facts of this case. What was done, what was excluded by a rule, that exclusion was introduced in the main statutory provision. Supreme Court held that the rule is invalid because it traveled beyond the scope of the rule-making power. And Supreme Court further held that yes, the insertion may be valid, but it cannot be given retrospective effect. Then, my lord, next judgment is Katikara Chintamani Dora, 74-1 SCC 567.
Yes.
Paragraph 66 of this judgment, may your lordship may kindly take your lordship to paragraph 66 of this judgment.
Should I see the judgment or the notes will be enough?
74-1 SCC 567.
Paragraph which one?
Paragraph 66. Prithvi cotton mills have been relied on.
Yes.
Well, the main sum and substance of the judgment is that the legislature has to act within its legislative competence. I am not making this submission, I made it clear. If it wants to neutralize the effect of a judgment, it must remove the basis of the judgment. Now, what was the basis of the judgment? That at any time, it is an expression which is possible of widest possible connotation. And it basically gave an, what should I say, an unbridled power to the executive, that is, the assessing authorities or the taxing authorities, to, make assessments for periods any prior period. If your lordship kindly takes 179 2DII, your lordship will find all those assessments for any period prior to the commencement of the Amendment Act. Those assessments would be validated irrespective of the fact, this is one step further, irrespective of the fact whether those assessments have been made within 3 years or 6 years. It gives again an uncanalized, unbridled power to these taxing authorities to make assessment which is, in my most respectful submission, would directly offend 265 of the Constitution. So, this is what is Chintamani, Katikara Chintamani. Then Amarendra Kumar Mahapatra. This is 2014 4 SCC 583. The relevant paragraphs would be 21.1. If your lordship kindly takes 21.1, I. What is the true nature and purport of the impugned legislation? More particularly, this is a legislation which was introduced by the state of Odisha for regularizing the services of the temporary or the ad hoc employees. And it was contended that this is directly against the Umadevi principle. Kindly take what is the true nature and purport of the impugned legislation. More particularly, is the impugned legislation a validation enactment, or is it an enactment that grants regularization to those appointed on ad hoc basis? Kindly take paragraph 27. This judgment is not at all applicable. Kindly take paragraph 27.
Yes.
In the case at hand, the state of Odisha had not suffered any adverse judicial pronouncement to necessitate validation act, as has been the position in the generality of the cases dealt with by this court. The title of the impugned legislation all the same describes the legislation as a validation act
the title of a statute is no doubt an important part of an enactment and can be referred to for determining the general scope of the legislation, but the true nature of any such enactment has always to be determined not on the basis of the label given to it, but on the basis of its substance. So this was not a case of validation act at all. So this is not applicable to the facts of this case. Well, next very interesting is that another judgment was cited. This is on a different line, different context. This is 2020 volume 20 SCC 57 Union of India versus VBF. I believe this judgment was cited to my lord to canvass before lordship that the state legislature has the competence to enact, my lord, clarificatory amendments.
Yes.
And my lord, paragraph 23 to 23.4, my lord, this is basically a summary of case laws on retrospectivity or clarificatory. Kindly take 23 to 24 and kindly mark the first judgment in that series, referred to in that series. Yes. SBI versus V. Ramakrishnan. This is one such judgment again relied on by Mr. Kaur. So, these law is well settled. As held by the Constitution bench in this judgment rendered in the case of this. Just 1 minute. Yes. Both, my lord, in this S. Ramakrishnan and the other one cited by Mr. Kaur is another SBI Ramakrishnan and UI versus Union of India versus BPF. Then another judgment which was cited by Mr. Kaur was yes, these are the two judgments, nothing more he cited. Correct. I'm sorry. So these are the two judgments cited on retrospectivity and clarificatory, nothing more. Then, my lord, the third judgment, next judgment which was cited by Mr. Kaur is Rai Ramakrishna. That is, my lord, 1963 SCC online SC 31, which is equal to 50 ITR 171. Well, in this case, the Supreme Court held that the legislative power would include the subsidiary or auxiliary power to validate a law which have been found to be invalid. Similarly, if a law passed by the legislature is struck down by the courts as being invalid for one infirmity or the other, it would be competent for the legislature to cure the infirmity and pass a validating law so as to make the provisions of the earlier law effective from the date in which it has passed. Now, in this case, what happens, in order to save the section 179 2D as it then stood, save it from the vice of unconstitutionality, the division bench introduced the concept of reading down or reading into, and substituted the expression at any time by the expression 3 years. That is determined by the court. The position would have been entirely different. Perhaps the state legislature would have been competent to introduce any other period with retrospective effect, even so, had this particular period had not been specifically fixed by this honorable court. What the legislature did, legislature introduced, instead of at any time, the legislature now introduced the concept of 6 years, which goes strictly against the law as laid down by the honorable division bench of this court, which stood affirmed by the honorable Supreme Court not once but twice. Under these circumstances, where a period when it has been specifically provided by the division bench and this judgment still holds good, that it should be 3 years and nothing more. It was in my most respectful submission before Lordship, it was not competent for the state legislature to rewrite what the division bench has already fixed. Otherwise, my lord, what will happen, my lord? Any judgment rendered by this court can be rewritten. It is not a, my lord, it is not a kind of nebulous term like reasonable period, not a nebulous time like my lord, what should be, what it should deem fit and proper. It was, the term was fixed. The term was 3 years. And my lord, to top it all, they went overboard. For the past periods, irrespective of 6-3, whatever it may be, they are whatever assessments they have made, that would stand validated. Now, my lord, now the next judgment. Now we come to the submissions made by Learned Advocate General. My lord, Learned Advocate General, the judgment, my lord, which Learned Advocate General last cited, it is very interesting. Why this judgment was cited, I don't understand. My lord, this is State of Rajasthan versus Ashok Khetolia. In this judgment, the Supreme Court held that the state laws, while enacting laws for municipalities, have to, or make laws for municipalities, must take into account the constitutional provisions provided for in Part 9, capital A of the Constitution. There is no capital to that provision. The state legislature has to act within the confines of Part 9A when it is enacting law for the purpose of municipalities. When it will be enacting law for the purpose of panchayats, it has to act in conformity with the constitutional provisions contained in Part 9. Because Part 9 was 73rd Amendment, Part 9A was 74th Amendment. How this judgment helps the case of the state, I fail to understand. It is unbelievably, my lord, it is not at all. What should I say? It's not at all opposite, rather it is not. The other judgments which have been cited by Learned Advocate General, and again, my lord, the power to tax. My lord, there cannot be any equity, intendment or intendment equity about tax. My lord, this is well settled. Justice Rowlatt, speaking in the case of Cape Brandy Syndicate, held that in fiscal statute there cannot be equity. There is no place for equity. There is no place for intendment. But my lord, more so, my lord, there is no place for any nebulous expression like at any time or ordinarily. This is not done. Now, my lord, now I would beseech your lordship to kindly consider a very recent decision of the Supreme Court, Madras Bar Association. Well, your lordship will find, my lord, everything has been dealt with in this judgment. Can I take this judgment for once? First, my lord, kindly come, my lord, Madras Bar Association, this series of cases, always has been, a challenge has been thrown as to the composition of, my lord, tribunals, statutory tribunals as well as mainly statutory tribunals. Now, my lord, this composition of the tribunals and the appointing and the selection constitution of the composition of the selection committee for the purpose of selecting members to this tribunal, to these kind of tribunal. For example, my lord, it may be company law tribunal, it may be an income tax appellate tribunal, sometimes it is a tribunal under the Chartered Accountants Act, etc., etc. My lord, your lordship I will not take your lordship to the entirety of the judgment. Just for the sake of completeness, I am giving the relevant paragraphs. 41 deals with, my lord, the first case. 46 to 48 deals with, my lord, the third case, MBA 3. Then, my lord, kindly come to 83. It deals with, my lord, it's a summary of MBA 1 to MBA 4. Well, these are the series of cases. Then, my lord, kindly come to paragraph 116. This is so relevant. This is valid where the general principles of law have been laid down. Kindly take 116. Consequently, once, my lord has got that. Consequently, once the court has struck down a provision or issued binding directions, after identifying a constitutional defect, Parliament cannot simply override or contradict that judicial decision by reenacting the very same measure in a different form. What Parliament may legitimately do is to cure the defect identified by the court, whether by altering the underlying conditions, removing the constitutional infirmity, or restructuring the statutory framework in a manner consistent with the court's reasoning. If it has to be consistent with the court's reasoning, then it cannot be 6 years under no circumstance. A valid legislative response must therefore engage with and remedy the constitutional violation pointed out by the judiciary. It can only merely restate or repackage the invalidated provision. Well, one thing I missed out, I'm sorry. What was the submission made by the learned attorney is somewhat akin to the submission made by learned advocate general in this case. Kindly take paragraph 83 for once. I'm sorry, I should have pointed it out. Kindly take paragraph 83. I'm so sorry. Malad, in response, kindly take the submissions which were advanced on behalf of the union by learned attorney. In response, the learned attorney general argued that the Parliament is empowered to cure defects identified by the court through fresh legislation, and that its collective wisdom should not be overridden by judicial intervention. He maintained that determining the service conditions of tribunal members is a matter of legislative policy warranting judicial restraint. Directions issued by the court, kindly take what was the submission made. In absence of legislation, he said, are merely suggestions, not binding. He argued that a subsequent law cannot be struck down from deviating from such directions, and judicial review of ordinance must be confined to the standard grounds of review applicable to legislation. I've read 116, kindly take 123, because 116 and 123, identical observations have been made, so it's relevant. Kindly take 123 for once.
Yes.
Thus, a clear distinction, my lords, got that? Thus, a clear distinction must be maintained between directing legislation and reviewing legislation. The former is forbidden because the court cannot function as lawmaker. The latter is indispensable to preserving the supremacy of the Constitution. Where the court identifies constitutional infirmities and issues mandatory directions to ensure compliance with constitutional principles such as those concerning independence, composition or tenure of adjudicatory parties, those directions are binding. Parliament may respond by removing the basis of the judgment through curative legislation, but it cannot simply enact a statute that reproduces or perpetuates the very defects the court has critiqued. 179 2D II is, my lord, repackaging of, my lord, second proviso to section 179 2D as it then stood. Nothing more than that. Thus, while judiciary cannot dictate policy, it can and must ensure that legislative choices conform to the Constitution. Judicial restraint in lawmaking does not imply judicial abdication in constitutional jurisdiction. Kindly now take, my lord, paragraph 120. I'm coming back to paragraph 120. Therefore, we do not find, this is addressing the argument made by the learned attorney in that case. We do not find merit in the argument of the learned attorney general that Parliament has discretion to ignore the decisions of this court. Then, my lord, kindly take paragraph 121. The second central contention advanced by the union is that The court cannot compel parliament to legislate in a particular manner. This principle is undoubtedly correct. The court has repeatedly acknowledged the institutional limits of judicial power and cautioned against intruding into the prerogative of the legislature by dictating the precise contents of a statute. The constitutional scheme does not permit judiciary to prescribe the text of a law or to mandate that the parliament adopt a specific policy choice. However, this proposition does not carry the matter very far. While the court cannot require the parliament to enact a law in a particular form, it unquestionably retains the authority and indeed the constitutional obligation to examine the validity of any law that the parliament enacts. Judicial review is a basic feature of our constitution. If a legislative measure infringes fundamental rights, violates structural competence such as separation of powers, of judicial independence, exceeds legislative competence, or frustrates binding constitutional directions, the court may strike it down. The inability to compel parliament to legislate in a specific manner does not translate into an obligation to blindly accept any law that the parliament enacts. Now, my lord, now kindly take paragraph 140. But this is how they address the non-obstante clause. Because what they have done, they have merely shifted the same content as it has been done in this case. 140. Merely shifting the same content from amended section 184 of the Finance Act into sections 3, 5 and 7 of a standalone statute while using the non-obstante formula, notwithstanding anything contained in any judgment or order, does not cure the constitutional defects. It simply reenacts them in another avatar. The impugned act therefore does not cure the law declared earlier but consciously defies it. Equally, the learned Attorney General's present defense of the impugned act is a verbatim reprise of arguments that have been already considered and rejected in the earlier round. The Union contended that the directions regarding, well, this is regarding the facts of that case. Kindly come to paragraph 142. Therefore, the provisions of the impugned act cannot be sustained. They violate the constitutional principles of separation of powers and judicial independence, which are firmly embedded in the text, structure and spirit of Constitution. The impugned act directly contradicts binding judicial pronouncements that have been repeatedly clarified. The standards governing the appointment, tenure and functioning of tribunal members, instead of curing the defects identified by this court, the impugned act merely reproduces in slightly altered form the very provisions earlier struck down. This amounts to a legislative override in the strictest sense, an attempt to nullify binding judicial directions without addressing or underlying the constitutional infirmities. Such an approach is impermissible under our constitutional scheme because the impugned act fails to remove the defects identified in prior judgments and instead reenacts them under a new label. It falls afoul of the doctrine of constitutional supremacy. One more paragraph I would like to cite from this judgment, where it quotes from, my lord, NHPC judgment at paragraph 118.
Yes.
Read 118. Where a legislative measure attempts to nullify or circumvent a binding constitutional judgment without curing the underlying defect, it not only exceeds the parliament's authority but also violates the doctrine of constitutional supremacy itself. This has been aptly discussed in the decision of NHPC versus State of Himachal so and so. The case arose of a long-standing dispute concerning the imposition of water cess or royalty by the State of Himachal Pradesh on hydroelectric projects operated by NHPC. Earlier, certain notifications issued by the state were set aside by the Himachal Pradesh High Court, holding that the state lacked legislative competence under the constitution to levy such cess on hydroelectric projects which were under the control of the union government. In response, the Union State Legislature enacted the Himachal Pradesh Water Cess on Hydropower Generation Act, which purported to retrospectively validate the earlier imposed and revive the collections that had been invalidated by the court's judgment. NHPC challenged this new legislation before the Supreme Court, contending that it amounted to legislative overruling of a judicial decision and violated the doctrine of separation of power. The court held, what follows from the aforesaid judicial precedent is a legislature cannot directly set aside a judicial decision. However, when a competent legislature retrospectively removes the substratum or foundation of a judgment to make the decision ineffective, the same is a valid legislative exercise, provided it does not transgress on any other constitutional limitation. Such a legislative device which removes the vice in the previous legislation which has been declared unconstitutional is not considered to be an encroachment on judicial power but an instance of abrogation recognized under the Constitution of India. The decisions referred to above manifestly show that it is open to the legislature to alter the law retrospectively, provided the alteration is made in such a manner that it would be no more be possible for the court to arrive at the same verdict. In other words, the very premise of the earlier judgment should be removed, thereby resulting in a fundamental change of the circumstance upon which it was founded. The power of legislature to legislate within its field, both prospectively and to a permissible extent retrospectively, cannot be interfered by courts, provided it is in accordance with the Constitution. It would be permissible for the legislature to remove a defect in the earlier legislation as pointed out by the Constitutional Court in excess of its power of judicial review. This defect can be removed both prospectively and retrospectively by a legislative process, and previous actions can also be validated. However, when a legislature merely seeks to validate the acts carried out under the previous legislation, which has been struck down or rendered inoperative by a court, a subsequent legislation without curing the defects in such legislation, the subsequent legislation would also be ultra vires. Such an instances would amount to an attempt to legislatively overrule a court's judgment by a legislative part and would therefore be illegal and a colorable legislation. The role of judiciary in galvanizing our constitutional machinery, characterized by institutional checks and balances, lies in recognizing that while due deference must be shown to the powers and actions of the other two branches of the government, the power of judicial review may be exercised to restrain the organs. The power of judicial review is a part of a basic structure of a constitution which is premised on the rule of law. Unless a judgment has been set aside by a competent court in an appropriate proceeding, finality and binding nature of a judgment are essential facets of the rule of law, informing the power of judicial review. In that context, we observe that while it may be open to the legislature to alter the law retrospectively so as to remove the basis of judgment declaring such law to be invalid, it is essential that the alteration is made so as to bring the law in line with the decision of this court. But this has not been done. Well, they have simply overruled the judgment rendered by a division, legislatively overruled the judgment rendered by a division bench and enacted I, making 6 years, and II is all the more, my lord, it's a direct incursion into, my lord, the judicial domain of the domain assigned to the judiciary, a direct inroad. Unbelievable. They are, my lord, and they say in their bill that I am overriding. This is a brazen act on the part of the legislature. A lordship will kindly take, if enacted, kindly take paragraph 14. The rule of law would cease to, I am only reading the bold lines with bold letter. Yes. The rule of law would cease to have any meaning if the legislature is at liberty to defy a judgment of a court by simply passing a validating legislation without removing the defects forming the substratum of the judgment by use of a non-obstante clause as a technique to do so. Next, my lord, bold letter. I will just read the paragraph 14. The legislative device of abrogation by enacting retrospective amendments to a legislation as a means to remove the basis of a judgment and validate the legislation set aside or declared inoperative by a court must be employed only with a view to bring the law in line with the judicial pronouncement. Abrogation is not a device to circumvent any and all unfavorable judicial decisions. If enacted solely with the intention to defy judicial pronouncements, such an amendment act may be declared to be ultra vires and as a piece of colorable legislation. But this is again, my lord, not to serve the oblique agenda of defying court's order or stripping of its binding nature. My lord, then there are several other. Kindly take the summary at paragraph 15. Summary is there, paragraph 15. There is no legal impediment to enact a law to validate a legislation which has been held by a court to be invalid, provided such a law removes the basis of the judgment, curing the defects of the legislation as it stood before the amendment. The validating legislation may be retrospective. It must have the effect that the judgment pointing out the defect would not have been passed if the altered position as sought to be brought in by validating statute existed before the court at the time of rendering its judgment. Retrospective amendment should be reasonable and not arbitrary, and must not be violative of any constitutional limitation. Setting at naught a decision of a court without removing the defect pointed out in the decision is opposed to the rule of law and the scheme of separation of powers under the Constitution of India. Abrogation is not a device to circumvent an unfavorable judicial decision. If enacted solely with the intention to defy judicial pronouncement, an amendment and validation act may be declared as ultra-vires. But my lord, may I just summarize, my lord? The summary would be, my lord, as we pointed out in our opening submissions, this Amendment and Validation Act of 2022 is a legislative device to add, my lord, to basically overrule the decision of a division bench of this honorable court, which also stood the test of being, which also was tested in the Supreme Court. Interestingly, my lord, the state has made submissions in this case. The state did not even challenge those decisions. State never preferred appeal against the division bench judgment. State never made any application for review of the judgment rendered by the division bench. State accepted the judgment. My lord, KMC is merely a creature of the statute. It is not the author of the legislation. My lord, when your lordship will find second proviso to section 179 2D as it then stood is equivalent to, my lord, the 179 2D II of the present form. My lord, there's the new avatar. So far as 179 2D I is concerned, when when this honorable court has held that it should be 3 years, the amendment could have been made in line with the decision rendered by the honorable division bench being 3 years, not anything more. Thirdly, my lord, the Limitation Act applies to suits, application, appeals. Limitation Act does not apply to, my lord, assessment proceedings. My lord, it is a fact, my lord, if there is a case of fraud, etc., my lord, obviously, my lord, an extended period of limitation is available to any, my lord, revenue authority. There is no cavil to that proposition. Whether the state has legislative power to make laws, enact laws regarding municipalities, but that's not my case. But the state had made a submission that it has to enact laws in terms of Part 9A. That is also not my case. It has to be done in that way alone. My case is that you have the legislative competence, you can enact the laws, but you cannot enact laws to, my lord, abrogate a decision of the court without removing the basis of the judgment. So my most respectful submission, and everything triggered, my lord, we were not even informed. In our case, we were not even informed when we made an application for refund, because the judgment required the authorities to undertake a process of assessment in terms of the judgment rendered by the honorable court. When the application for refund, then for the first time, they referred to this amendment. Look, now everything we have taken care of. Now, nothing is payable, you pay us. You pay us and you satisfy the requirements of 179 2D as it stands now. So, my lord, this is, my lord, I do not wish to make that submission, but I am constrained to make that submission. My lord, the actions of the state are not befitting the state as such. It's not befitting the role of a welfare state. The actions of a state are somewhat clandestine in this matter. They keep the amendment under wraps. They don't point out the amendment to the Honorable Supreme Court when the Supreme Court is insisting of the matter. And then they suddenly, when we make an application before release of the refund, they This is what. These are my respectful submissions. If your lordship permits us, subject to your lordship's pleasure, obviously, we will file a short notes. But may I take your lordships kindly? I am extremely grateful for bearing with us. Extremely grateful.
Manjam, thank
Because
you so
of-
much. You summarized it very, in a concise manner, very helpful.
Because that is,
point.
I have
limitation-
my own limitation. So my summary is also limited.
No, but I like that limitation point.
Grateful, man. I take your lordships kindly.
My lord, most
I
of
hope
the,
you'll follow your senior.
yes, I'll be even briefer. Kindly, my lord, please. I'm not at all going to, my lord. The judgments that have been distinguished, that have been taken through, my lord, to your lordship, the challenge there is 179 2D, the provisos. My additional challenge is that of 180 subsection 2 proviso and 232B. And I had placed before your lordship my opening submissions that 232B in the year 2023 seeks to reopen provisions relating to ARV, which were not in the statute book. It had been done away with after publication of the scheme under 1st April 2017. When they do so and they unlock those provisions, then 179 2D provisos also get revived. Because the language that they use in 232B is, and if your lordship kindly bears with me on this, please have a look at 232B, the language that they use.
Yes.
Notwithstanding anything contained in this act, the provisions of subsection 1, 2, 3, 4, 8, and 9 of section 171, subsection 1 of section 174, and sections 175, 179, 180, 182A, and 185, which were in force immediately prior to the commencement of the KMC Amendment Act 2006, and subsection 3 of 174 shall continue to be enforceable in respect of any action as to be taken for the purpose of assessment of annual valuation and levying of property tax or any step relating thereto for any period prior to publication or enforcement of the scheme under subsection 1 of section 174. Read with clause A of 179 of the amended provision. That means, as I had submitted in my opening submissions, the UAA system had first come into vogue in 2006 by the 2006 amendment. Then it was, those provisions were kept in abeyance in two methods. One, 174.3, which kept the provisions, certain provisions in abeyance because the scheme had not yet been prepared. And then 232A, which was enacted in 2011. They kept the provisions in abeyance till the scheme was published. Now, once the scheme got published on 1st of April 2017, all the ARV provisions were not subsumed by that scheme. They were no longer alive. And what was alive was the UAA system. Now, after that in 232B, they are seeking to revive the provisions of the ARV for the period prior to 1st of April 2017. Here, if 179 sprouts back, then the second proviso also sprouts back. If it sprouts back in my reciprocal submission, it cannot go for an unlimited point of time because of Sahujan, and Sahujan should also revive. In that case, any retrospective assessment which the corporation seeks to make in respect of ARV valuations cannot be for more than 3 years from the last date of the ARV. That is 31st of March 2017. Can't be for more than 3 years from that date, because after that the ARV had stopped existing. That was my challenge, Milord, to 232B. Insofar as 180 subsection 2 proviso is concerned, question of fraud, etc. suppression was mentioned here. What I would like to point out to your lordship is, (180) subsection 2 subclause 9 proviso provided that such revision of annual valuation of any land or building shall ordinarily be made within 6 years from the date of occurrence of any of the above circumstances, but such period shall not apply where the owner or the person liable to pay property tax fails to submit return under section 182 or suppresses the occurrence of any such circumstances. Here, my lord, there are two parts. First is it says that it shall be ordinarily made revisable for a period of 6 years from the date of such occurrence. The word ordinarily spoils the provision. The moment the word ordinarily, a nebulous word like ordinarily comes in, then there is always discretion left on the executive acting under the statute to either do it in case A or not do it in case B. The reasons when the extraordinary or ordinary thing would prevail are not mentioned in the provision. Therefore, my lord, this hits it under Article 14 vagueness. Any fiscal statute cannot have such provisions like it can be ordinarily done within such day. It should ordinarily in usual course be done on such day. If it comes with that vagueness, then automatically it gets hit. That retrospectivity gets hit. One. Number two, if your lordship has seen in all the fiscal statutes, not I have brought them, I'll not place before your lordship, I'll place it in my notes. In all the fiscal statutes, there is a provisioning for fraud to be undone. But that provisioning comes with a time limit. There is not a single fiscal statute in India where the provisioning is without a time limit. Here, provided the proviso, the second part says, or the person liable to pay property tax fails to submit return under 182 or suppresses the occurrence of any of the circumstances, then such period shall not apply. That means technically, no time limit is being ascribed to reopening. They can reopen a 100-year-old issue. This is completely in the teeth of the Sahu Jain judgment and Article 14. Everywhere it has been stated. In the Income Tax Act, I think now 6 years for a particular period, 3 years for a particular value of escaped income, 6 years for a larger value of escaped income. Beyond that, you can't go. This keeping it open-ended till negative infinity is not provided for in any of the provisions of the fiscal statute. So there also, my lord, it is illegal. Now, my lord, page 58 of the writ petition would go to show, though on reply, not on facts, that the certificates of enlistment on the basis of which these entities came into possession were in the knowledge of the corporation from the contemporaneous point of time. Yeah. Please have a look at page 58. From the second onwards, second box onwards, second quarter 2008-9, CE is 4th July 2008. So it was within the knowledge of the corporation that on 4th July 2008, this gentleman had come in, or this entity had come in. If your lordship turns over, my lord, to the next page, again, fourth quarter 2009-10, they are making another assessment now, but the CE is dated 30th of December 2009. Similarly, the next one, the one after, that's the fourth block, the third block on page 59. CE is 2nd November 2011. The next one, CE is 5th November 2012. Next one, 9th January 2014, which means at all material times, the certificates of enlistment for these purposes have been granted by the corporation itself. And this law is well settled that one arm of a particular body cannot say that that arm was aware of something, but the other arm was unaware. Therefore, it's a body as a whole. Therefore, they are aware of it from those points of time. They have chosen not to make a retrospective assessment. Now, under 232B, they are destroying Sahu Jain and going back and making that assessment. That, my lord, my school submission could not have been granted. Two judgments which Mr. Mojumdar has gone through all the judgments, my lord. Admittedly, I have very little to ask to add, but only
Madras.
Madras I'll rely on heavily, and Madras, but Khetolia first. A submission was made at the bar by the learned advocate, and therefore it must be held to be something which is worthy of consideration. According to the learned advocate, 2022 12 SCC 185, that state of Rajasthan versus Ashok Khetolia says, and this was his submission, that in a part 9A action, where a municipality's action is being considered, then a statute cannot fall foul of the constitution unless shown to be dehors part 9A. That was the submission. A statute cannot fall foul of the constitution unless it is shown to be dehors part 9A, which impliedly means that the other parts of the Constitution, particularly part 3, fundamental rights, would have no manner of application. With great respect, I have gone through this judgment. I do not find anything like that laid down here. Please have a look at Khetolia. Accent. Khetolia, Khetolia is perhaps, if your lordship kindly sees.
Give a copy.
Yes, yes.
No, I have two. I mean, I have one.
Oh yes, I'll just share it with my sister. She'll be seeing it together with me. Lord, what was under consideration here is completely different. There is a provision in the Constitution. Because if this is the law which the learned advocate says, learned advocate general, with great respect, my lord, kindly see, my lord, part 9A, which came by the 74th Amendment. There's a provision, this came in by the 74th Amendment. There's a provision 243Q, subsection 1 proviso. Please have a look at 243Q, subsection 1 proviso, only for the purpose of interpreting this judgment, nothing else. Otherwise, I wouldn't have taken lordship there. 243Q1 says, there shall be constituted in every state a Nagar Panchayat for a transitional area. That is to say, an area in transition from a rural area to an urban area. B, a municipal council for a smaller urban area. And C, a municipal corporation for a larger urban area in accordance with the provisions of this part, that's part 9A. Provided that a municipality under this clause may not be constituted in such an urban area or part thereof, as the governor may, having regard to the size of the area and the municipal services being provided or proposed to be provided by an industrial establishment in that area, and such other factors as he may deem fit, by public notification, specify it to be an industrial township. We're not pausing here for a moment. Therefore, the governor has been given the power to specify industrial townships. Where? A place like Jamshedpur, where all the civic services are maintained by the Tatas in and around the factory. Such places where the private individual, private entrepreneur maintains all the civic services, that can be held as an industrial township, and there no municipality can be formed. That is, the verdict of 242Q1. In the judgment at hand, legislature had directly, by enacting a law, made provisions for certain portions to be declared as municipalities and municipal councils and the like. Challenge was that without the governor having notified industrial townships under 243Q1, this legislature could not have gone ahead to itself by statute law notify any municipality. That was negated by the Supreme Court. Supreme Court, on the contrary, said quite contrary to what the learned advocate with great respect has submitted. Supreme Court said, this does not take away, part 9A does not take away the right of the legislature to enact laws under its usual lists, in list 2, where under list 2 entry 3, there is also always a provision for enacting laws for municipalities. That means legislature can straight away by a law create a municipality for which no prior governor's notification under 243Q1 is necessary. That's the intent of Khetolia. Where it says that for a law to be touched on the anvil of the Constitution, if it relates to part 9A, only part 9A violation can be looked into and no other part can be looked into. I have not found. Khetolia 1, Madras Bar Association, I am heavily relying again. Madras, I need not waste your time. But your lordship will find there a great emphasis has been laid on the fact that you can't make old wine in a new bottle and get away. There in the Finance Act, there were certain provisions relating to appointment of chairman, etc., their posts and the like. That provision was struck down by the Supreme Court. And the state and the union also came and agreed on certain changes in that provision. Thereafter, on the basis of the part agreement of the union and striking it down, the Supreme Court actually said that those portions of the Finance Act were bad. Subsequently, what the union legislature did was they enacted additional provisions in a different act and made it almost look similar to those provisions which had been struck down. Supreme Court said, old wine in a new bottle, you cannot do. If we have struck down the provisions as appearing in the Finance Act, you cannot bring by means of your legislative power in a different statute similar provisions and try to see them through. That's Madras, but Madras really deals with the entirety. Another one small point, Milord, which I'll be concluding with. Milord, 179 2D provisos, Roman 1 and Roman 2, which Mr. Mojumdar has challenged, in my decimal submission would not apply to ARV, for the simple reason that 179 2D in the present avatar as under challenge came into the statute book on 7th of August 2019 at a time the UAA had already come in. So my reciprocal submission is, for the purpose of my challenges, 179 2D even otherwise cannot permit anyone under ARV to go back for a period of even 6 years. Please have a look at 179 2D, the date it has come into force.
Seven 8/2019.
Yes. So 7/8/2019, 7/8/2019 is the date on which it has come into force. Kindly, my lord, again recall, 1st of April 2017 is the time from which UAA has come in. And all the provisions of ARV have been removed. UAA has come in. So when a 179 2D proviso now appears, 1 and 2, it means to say it has to be construed in the light of the new system. That's the UAA system. Therefore, for my provisions, for my purpose, all the retrospective assessments made under the ARV cannot be supported even by 179 2D. This is in addition to Mr. Mojumdar's points that even otherwise 179 2D cannot travel for more than 3 years behind in view of Sahujan, old wine, new bottle theory. Now, Lord, there's just one. Well, I'll have to let me, Lord, get my house in order. Otherwise, it will be difficult to continue. Thank you, Lord. Now, just only last one part. There's a submission advanced at the bar, and I went back to the drawing board, and I found judgments also negating that. Submission was that it's now the settled law that in fiscal statutes, unforeseen hardship or unforeseen adverse circumstances cannot be a ground to challenge. That was the submission advanced by Mr. Advocate while addressing your lordship, had verbally referred to bits and pieces of various cost titles, saying that my lords know that in view of this now it's more or less settled that hardship cannot be a ground to challenge a fiscal provision. With great respect, judgment. With great respect, this is not the law. In the compilation that I had handed up to your lordship, Lord, I have given a judgment, which says something to the contrary. I anticipated this judgment would come. Kindly bear with me. Please see, my lord, 1989 3 SCC, আমাদের এই compilation এ আনিনি আমরা 1989 3 SCC 488. Which judgment is this?
Yes, please give me a moment. It's not there in the compilation, no?
It's not in the compilation.
Oh. There are the three judgments that I have found out where factors in which, while testing whether retrospectivity is violative of Article 14 of the Constitution, hardship or unprecedented financial burden have been taken to be relevant factors. Three judgments. 1989, Volume 3, SCC 488, paragraph 66. This is Ujagar Prints versus Union of India. 2005-7 SCC 725, paragraph 22. And 2016-15 SCC 125, paragraphs 14 and 19. আসেনি তো এখনো? Now, these I'll be just handing up with the relevant paragraphs marked. All these judgments very clearly say the 1989 one, the 2005 one, and the 2016 one, that the factors which are generally considered relevant in answering whether a retrospective provision is ex facie discriminatory or so unreasonable or confiscatory that it violates Article 14 and 19 of the Constitution are: 1, the context in which retrospectivity was contemplated; 2, the period of such retrospectivity; and 3, the degree of any unforeseen or unforeseeable financial burden imposed for the past period. Therefore, my lord, hardship really has a role to play. It is perhaps not correct to say that hardship would have absolutely no role to play. Lord, these are my submissions. Lord, these are my submissions. Lord, may I hand up to your lordship?
Yes.
Since in reply, both of them have cited new judgments, I'm requested by Mr. Kaur and Learned Advocate General that one day time can be given. Mr. Kaur has asked if Wednesday 10 minutes time can be given to him.
Contempt matter. Act, SPC Act, paragraph 28 and 20. Retrospective effect if damaging the petitioner's
Yes,
case.
just text me.
Wednesdays are not possible.
Any day convenient for your lordship?
15th? 15th.
15.
15th at 2 p.m.
My lord. Have cited judgments. Learned Advocate General. Yes, I told him he texted me.
15th? For both of them.
Yes, I've told them also.
As well as the advocate. The 15th will have.
Lord, kindly permit us to use a short supplemental note dealing with the judgments which have been done by Mr.
That you do with your written notes?
Yes, with my written note. I've already put in a small one, but I'll put in my.
Let's finish the argument.
Yes. Arguments are over. Arguments are over as far as I'm concerned.
Heard senior advocate, Mr. Majumdar and Mr. Banerjee, Arindam Banerjee, for the petitioners. List for further argument on 15th. बस अब नहीं आज हो गया the rest of the matters I'll take tomorrow.
Grateful, my lord. Paragraph 1419. Yeah, note down. Appearance law. আইটেম নাম্বার গুলো কত রে বলছে?
এই বললে ভাই
गोपाल का दिमाग का
One and
बड़ी बन रहा है बोले आलू चॉप बन रहा है देखो गोपाल का दिमाग का आप खाइएगा
next day, Monday, 15th. Yeah. 15th.
ঠিক আছে
লিখে দিয়েছি তোমার এজিকে, ঠিক আছে?
Thank you. हाँ हाँ
একবার